Good morning. I'd like to call this meeting to order. It is 9:06. Today is Friday, December 12, 2025. This is the second day of a two-day meeting of the Physical Therapy Board of California. Today we are meeting in the hearing room at Department of Consumer Affairs, 2005 Evergreen Street, Sacramento, California, 95815. We are also meeting virtually via a WebEx component provided by the California Department of Consumer Affairs. This is an official business meeting of the Physical Therapy Board. The board's role remains to maintain consumer protection and consult with local and state entities on laws and regulations pertaining to the physical therapy industry. We will take public comment on specific agenda items, and at the end of the meeting, there will be a comment section for items not on the agenda. Public comments must be specific to the agenda item that is being discussed. If you make a comment during a specific agenda item that is not related to the topic, you will be directed to hold your comments until we reach the appropriate agenda item. All comments that do not directly relate to an item on the agenda should be held until the agenda item for items not on the agenda. The board follows the Open Meeting Act, so while we do accept and appreciate public comments, we cannot respond to those comments. We do have a moderator on from the Department of Consumer Affairs to help us with the online participation today. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconferencing process. For those members of the public participating via teleconference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during public comment period, the moderator will direct you with instructions. This meeting is being recorded and the minutes of the meeting will be prepared. Can we please have roll call?
Karen Brandon,
Here.
Dan Q,
Here.
Bill Armstrong,
Here.
Kayla,
Here.
Tanya McMillian.
Here.
All members are present and the board has a quorum.
Thank you so much, Brooke. All right, can we please, may I ask the Vice President, Mr. Q, to read the board's mission statement?
The PTBC mission is to protect people of California by the effective administration of the Physical Therapy Practice Act.
Thank you. And before we continue with our agenda today, again, as board president, I would like to welcome everyone here today, board members, staff, stakeholders that came in specifically for this program, and also members of the public. All right, so we are going to be going to agenda item number 22. That is Consumer and Professional Associations and Intergovernmental Relations Reports. We will be going back to item number 21 after that. I would like to first call Department of Consumer Affairs representative from the Executive Office, Lucia Saldivar. Thank you so much, Lucia.
We also have a rather special guest this morning in the director of the Department of Consumer Affairs, Kimberly Kirkmeyer.
Can you hear me? Perfect. Good morning, Board President Brandon, board members, and staff. My name is Lucia Saldivar of the California Department of Consumer Affairs, and thank you all so much for the opportunity to provide some updates on behalf of the department. Firstly, I would like to introduce myself as one of the newest members of the department's executive team. I was appointed by Governor Newsom in October to serve as Deputy Director of Board and Bureau Relations. Prior to this appointment, I worked in the state legislature, most recently serving as Chief of Staff for Assemblymember Lisa Calderon, and also as her first legislative director. I also previously served as an Assembly Fellow and a Legislative Assistant in the office of Assemblymember Jackie Irwin. I am an alumna of the Hope Leadership Institute program and a member of the California Latino Capital Association Foundation, and it is a pleasure to meet you all this morning. We are also happy to welcome Shelley Jones to the department's executive team. Shelley was appointed by Governor Newsom as the Assistant Deputy Director of Board and Bureau Relations, and she brings 29 years of experience. She's been with the department since 2015, serving in several capacities with DCA's Board and Bureau Relations team and the Solid and Organizational Improvement offices. Prior to joining DCA, She served in multiple roles at the Juvenile Parole Board of the California Department of Corrections. And we are so very excited to be serving as your new Board and Bureau Relations team, and we look forward to working with all of you in our new roles. Also, as we near the end of another year, DCA is encouraging board members to review the list of required trainings to ensure continued compliance. As you may remember, sexual harassment prevention training is mandated for completion within 30 days of your appointment to the board and every 2 years thereafter. On October 27th, DCA launched its new sexual harassment prevention training in the Learning Management System, also known as LMS. If you completed the 2024-25 sexual harassment prevention training during that calendar year, the new training will automatically be assigned to your LMS account 2 months before your 2-year mark. If you have not yet completed the training for the 24-25 year, the new version was already assigned to your LMS account on October 27th. You should be able to log on and complete your training. Going forward, the compliance deadline will either be 2 years from that last completion date for those who already took the training, or by December 27th for those who did not. And upon completion of the new sexual harassment prevention training, it will be automatically reassigned to your LMS account 22 months from your last completion date. But if you have any questions or you need assistance accessing LMS or the training, please do not hesitate to reach out to memberrelations@dca.ca.gov. We are also officially in the season of giving, and DCA is honored to join in 2 annual charitable campaigns, the Our Promise California State Employees Giving at Work and the State Employees Food Drive. Every year through the Our Promise California State Employees charitable campaign, state employees, which includes board members, have the opportunity to support the nonprofit causes that they are passionate about through payroll giving or one-time donations. And these contributions have a positive impact on our communities, and it's another way to show that DCA cares for California. Please contact Board and Bureau Relations if you have any questions or you want more information on how you can contribute. The State Employees Food Drive is a collective effort to support food banks statewide, and collection boxes for non-perishable food items are available at 5 Sacramento area DCA offices. But for those who are not in the area, there are ways to support food banks online through the State Employees Food Drive website. Thank you for being part of the reason that DCA's Giving Spirit is helping those in need this holiday season. And lastly, in other news from the executive team, after 36 years of dedicated service at the California Department of Consumer Affairs, Director Kimberly Kirkmeyer recently announced that she will retire at the end of this year. Director Kirkmeyer began her career at DCA as a student assistant in 1989. She was appointed by Governor Newsom. She was appointed by Governor Newsom as DCA's director in 2019. And within her first 6 months on the job, she navigated severe wildfires and the start of the COVID-19 pandemic, including transitioning the department's 3,500 employees to telework. And Director Kirkmeyer is here today, and I would like to turn it over to her to provide some remarks.
Oh, first of all, am I on? All right. First of all, I just want to thank you for inviting me here today. This will be my last board meeting to speak at. So it's a little bit, sad. And I'll try to make it through. But anyway, I just wanted to thank you all for your dedication to consumer protection. It truly has been an honor for me to serve as the director of this incredible department. I always say we're like the most unique department in the state, and I could not. I don't care what anybody else says. I will argue that to my death. But it has definitely been an honor, and I'm very grateful to Governor Newsom for my appointment into this position 6 years ago. It's just amazing to me that it has been 6 years. It has flown by so much, and we've accomplished so much. It has been my honor actually for many reasons, including the wonderful and dedicated board members that I have met through my time and the ongoing relationships I will have with board members. You all are so hardworking. You're an inspiration to so many, and I just want you all to know that we are so grateful for the work that you do for the boards. It is not easy. Sometimes you have really difficult issues to deal with, and the fact that you do it with grace and you're just very humble. I just want to thank you for that. I know you all have incredible careers, and the fact that you want to dedicate your time to us means a lot. I also am grateful for the staff of DCA. They are truly the most hardworking individuals in the state. We work with very limited resources, and the fact that you have an executive officer, an assistant executive officer, and so many hardworking staff for your board, I hope you all appreciate that, because they do a lot with a little, and it means a lot to us that they run this board so well. And just really grateful for both Ms. Conley and Mr. Kaiser. I'm also just particularly grateful and thankful for I'm very proud of DCA's mission of consumer protection. And with that, I want to tell you why I'm so grateful to this board. When things become personal, it makes you really appreciate what individuals do in their careers. And for those of you that don't know my story, about 3 months into me being the director, my husband had a severe accident. His legs were completely crushed. And so he went through 3 months of in the hospital recovery and surgeries upon surgeries. But the PT that my husband met made all the difference in the world, and it made the difference between him living his life in a wheelchair or walking and being able to maintain a normal function. So this board will always hold a special place in my heart, as well as many other healing arts boards that helped along the way. It means people can work again and get their lives back and move pain-free. That is a huge thing for the lives and even for the state's economy. And I hope you all understand just the importance of the roles that you play in that. That's why it is so hard to leave, but it is also makes me so proud of the work that we have all done together, and we can only do it together. So with that, I want to thank you for your service, and also just please keep going and doing the great work for consumer protection that you do every day as your members on this board. So I am so grateful for you, and I just want to thank you for your service again. So with that, I'm just very grateful. And we'll open it up for questions for DCA.
This is very bittersweet for me as well. So I'll just get to the,
Oh, no. We'll do it.
dedication to them for their experience, their commitment and sacrifice and participation. So I thought it only right this composition of the board did the same thing in this trip. So you'll join Dr. Brandon and I. No, that's when I came to this board, I didn't come here to do this, first of all. I didn't know that I was ever going to be in a position of this leadership role. And at the time, I'll say that we had kind of a mentorship problem at the time. There weren't a lot of people that I could rely on. But while you were at the department, and then when you moved to the medical board, you helped me tremendously. I can remember coming up across things that even if I reached back and asked previous executive officers, what do I do here? They would say, I don't know. We've never had that happen before. Congratulations, that you're the first timer. And I would go out the back door of our board and go through the back door of the medical board and ask him what should I do? And how many times you helped me with that is part of the reason I'm here today. So we present this to you. This is signed by the current composition of the board. And we plagiarized your format and how you recognize board members. So
Thank you so much.
I have one more thing. Exit. Similar to an athletic system, retire their jersey. I have a number of retired jerseys in the halls that need to be seen now, but I don't have one in blue and gold. And I don't have director jerseys that I'd hang in my hall. So this one is for you. We have a copy that will be hanging in our hall. And just a fun trivia, you recognize the number and why? Tell you a funny story, right? When we first got here, we suffered with an antiquated data system called the Consumer Affairs System in CAS. And we all identified each other by the last 2-digit teller number. And so I had to go back through that archive and find out what your teller number was. We're 68, and the funny thing is, for the PTBC, I was 68 also. So eventually, when my jersey gets hung in the PTBC,
We'll be 68 together. Thank you so much.
Thank
Thank you.
And I think we should probably take about a 3-minute break to composition before we move along.
No problem. We can take a 5-minute recess. Thank you, everyone.
Thank you so much. I appreciate all of you.
Okay, welcome back. We are going to resume the PTBC agenda, item 22 with 22A. We just finished 22C. I'm happy to welcome FSBPT Director Michelle Sigmund-Gaines. She's going to give us an update from the Federation of State Boards of Physical Therapy. Thank you.
Thank you and good morning. For the record, Michelle Sigmund-Gaines, FSBPT. How am I doing for volume? Good? Okay. All right. Mr. Kaiser asked me to focus on some topics for you today. The first two, I'm going to go into a little bit more detail and then provide kind of a lightning round overview on a broad umbrella of data-informed decision-making and give some highlights to see your potential future interest for more in-depth presentations on the topics. But to get started, we wanted to focus on some updates to the ETS is making to the TOEFL English proficiency exam. They're making a number of enhancements or changes in the way the exam is administered, but perhaps the biggest item for jurisdictions to consider is that they're changing the existing scoring scale. And they're moving from what was discrete points on a 120-point scale with different categories to effectively a 6-point scale in half-step increments. Now, ultimately, this does make it align better to the CEFR, the Central European Framework on English proficiency across nations. And the other piece is that it starts January 2026. However, there is a 2-year transition period where ETS will be providing the TOEFL score reports with both score scales. So for jurisdictions that have specific requirements for the exam in rule, for example, you will still see the scores as they are presented today. But ultimately, during the transition period, the standard for TOEFL scores that the FSBPT puts out will need to be updated. And the reason for that is that the scales don't absolutely align. Kind of the key point on this slide is that, as an example, if you had a listening score of 20 under the new scale of the 4.5, that would be considered a passing score, but would not meet the standard that we have. However, if we were to raise it to a 5, then it would require a higher standard than we historically have had. So it's not sort of a slam dunk, if you will, implementing the new scale. There needs to be some thoughtful consideration on what an appropriate standard would be to make recommendations out to states. So going forward, there's more going on in English proficiency as far as potential for multiple different tests that are coming online, such as the Cambridge or the OET, that it is possible, depending on your jurisdictional requirements, that an individual might have to complete different tests for USCIS and the requirements that you have. And that is going to be wrapped into our deliberations as well. So our plan is to initiate a task force to look through the standards, look through the new exams, and make that recommendation for a new standard within the calendar year so that jurisdictions have time to take that information and make whatever adjustments you may need to make in your requirements in your jurisdiction. On the next topic, I'd like to focus on the HRRI Healthy Practice Resource. I believe I mentioned this briefly when I had the honor of being here back in March. But at this point, all of the modules for the resource are online. So I wanted to give a brief sort of sampling of that. You could follow along at hrri.org. But basically, the background here is the belief that promoting public protection involves making sure that health professionals are able to practice at the top of their ability and competence, and that issues with wellness or burnout can be detrimental to public health outcomes. HRRI sponsored some research to develop and validate an assessment tool to help practitioners self-reflect and determine if they feel that they are in that moment fit for practice, or if they need to make some adjustments in different domains. So this slide goes into that information. There's also a link that takes you directly to the self-assessment from this slide. And with that, I also wanted to bring in another perspective when we get questions about wellness and the relationship to a regulatory body and how that fits in. The United Kingdom Professional Standards Authority has, for a number of years, published a framework for determining what they describe as right touch regulation, which is simply not too little, not too much, and is a mechanism that is used in many countries to kind of assess how regulators are doing and try to walk that appropriate line. I know you won't be able to see all the information on this slide. The link at the bottom of the slide takes you to their website where you can download different materials. But the key illustration on the right side of the screen has to do with one of the fundamental tenets of right touch regulation. And that illustration is demonstrating the lines of defense for risk management. So the light blue that you're seeing in the center, the largest circle, is the individual practitioner themselves, their sense of professionalism and self-regulation. And then wrapped around that in the second line would be the context, the employer, the group, practice settings, schools, whatever their group affiliation may be, also has certain mechanisms and risk controls. And then the outside sort of candy layer, as I like to think about it, that's us. That's the regulators, which really should be that last line of defense, and only to the extent necessary to mitigate any risk to the public. So when you look at this, which seems like sort of a dry regulatory assessment model, you can see that the practitioner and the wellness of that practitioner is central to effective regulation. So this screen, it's a screenshot, but these are the 10 modules that are available that can be completed by an individual. These are all no cost. There is no fee associated with completing any of the modules, and it's completely confidential. It was important because of the sensitivity of the topic to make sure that nothing was being retained that could be requested under public records. Nothing was shared with a jurisdiction such as yourself if somebody were applying for credit. But it does require that individuals go through a self-assessment and a self-reflection component. And part of that pulls in learning resources that they're asked to review and comment on as part of that self-reflection, and then also grants them access to those learning resources and others if they're useful. Now, there is the option for an individual to put in minimal information to have the system monitor their completion and generate a certificate of education completion at the end of the completion of each module. Based on the review, that's been determined to be 1 hour of potential CE, and that certificate does have all the standard information that most jurisdictions require in order to grant credit. Just a brief view, this is a screenshot pretty far in. You can see on the left side, I've answered all of the assessment questions. You do end up with sort of a topical sort of slider and a summary on that. And then if I were to scroll the screen, if we were live under resources, is where you would start to see the additional resources that they had reviewed and their answers. Individuals do have the ability to print off in PDF so that they can save a copy of everything else, but otherwise, once they leave the site, none of that, their answers are retained. So for context, as of yesterday, this is a reflection of what's been reported to us at the Federation on what jurisdictions are considering or what may already fall under their current continuing education allowances. So there's about 17 jurisdictions here that have responded and are working forward. You can see that Mr. Kaiser has indicated that it appears that this may qualify under your alternate pathways for continuing competence. But I thought this information would be helpful as well. And then finally, if we look ahead on this particular tool, there's currently an effort to refresh the resources that are a component of the assessment, because that's very important to provide those as well. Part of what they're looking for is to make sure that nothing's been moved behind a paywall that would indicate a cost, nothing's been removed, and of course to bring in new material so it stays relevant. That is going to be an ongoing regular review process. I also wanted to highlight that some jurisdictions are exploring the use of the Healthy Practice tool as part of their investigative and disciplinary process. And there's been some variation on that. I don't have a lot of detail, but it is an interesting application of that, not just for continuing education credit, but to put it into some of those integrated processes as well. And I do also want to highlight that even though I'm presenting to you as the PT board, the tool is actually designed open-ended for all healthcare professionals, and they can indicate that, and there are certificates that can meet other professions. So we felt it was important, given the sort of level of burnout and workforce issues in healthcare in general, that it's a tool that would be useful. I've gone through the modules. It was very enlightening. I would encourage all of you to try one or two, but that's where that tool stands. And then as a final lightning round, which is trying to give you the high level on what could probably be another hour's worth of presentations. But data-informed decision-making, I know that's all near and dear to all of our hearts on being able to make better decisions that are human-centered but informed by data and actual information. 3 key strands have been a focus for the Federation in the past year and will continue to be going into 2026. The first one is what we call affectionately strengthening the ELDD, which stands for just the database of exam, licensure, and disciplinary actions. So it's all the information that comes in from all the jurisdictions, such as yourself, information that we can push out to jurisdictions such as exam scores and disciplinary actions in other jurisdictions. So it's that mechanism. Due in large part to continued participation of compact states in the compact statute, it does require frequency and participation in sending data at least weekly. As a result of that, the quality of the data in the shared ELDD has improved significantly. Before Federation staff were having to go out, review all your websites and bring that information back in. Much of that is being automated. Some of it has been brought up to daily updates. The next piece of that, and I'm actually going to skip to the centralized look. It's to a level where members of the Federation jurisdictions have been wondering about whether it would be appropriate for us to look at a central licensee lookup. So sort of a federated information source. If you're familiar with the FSMB state medical boards, they have DocInfo. Nursing has a similar thing where any member of the public can go and they can search for a provider, and they can see not just what they can see in your jurisdiction where they can look up the status of their California license, but frequently you have a practitioner, right, that holds licenses in 2, 5, 12 states, and all of that would be available for public view. We've had some discussion with jurisdictions, and we're working out what that could look like and how to do it in such a way that it respects all states' requirements around public information, does not create any kind of regulatory burden, but we will continue to explore that, seek your input, and see if it makes sense for us to move in that direction. And then jumping back into the middle, workforce data. I'm sure your legislature, just like mine back in Oregon, is always interested in key information. It is difficult for a licensing board to know some of the level of detail that they want around workforce. Our information as jurisdictions tends to be around whether they hold a license or not, but not necessarily are they actively practicing, where are they practicing, are they even practicing in the state or just holding on to a license. So getting that cross jurisdiction, having a standard data set for capture, and because folks move around so much or might hold licenses, it's important for us to know, not just within one state, but frankly, at least regionally, if not nationally, to be able to share data amongst ourselves and be able to know where folks are going and where we have the hot spots. But as I mentioned before, healthcare is not a silo. The shortages, when you talk about coordinated care teams and in some rural areas, it's important to know what the workforce elements are across professions. And so we're also doing work on making sure that what we do is extensible and can apply to all professions. So with that, that's my lightning round. I know, just a teaser on that. I would love to come back and present on any one of those topics or a deeper dive just on our data efforts at a future meeting, but I'll pause and happy to answer any questions.
Thank you, Michelle. This was very enlightening. I'm very much a proponent of wellness and in healthcare, especially for healthcare providers. Just a quick question. How long does it take to time-wise to take all these modules?
In some of the testing, we've determined that it takes approximately an hour. Now, it depends on the individual, like with any CE course, right? Some folks can, there is that intention of what they put into it as well. But on average, an individual, it'll be about 1 hour per module.
Thank you.
Thank you so much. It's so exciting to hear what FSBPT is doing. I think if I had like so much time, I would be like deep diving into each individual piece here because it's so valuable. You know, being in practice for almost 30 years, I know we have some students in the room, and I just love to hear that the wellness starts with you. And a lot of what we see in regulation is people who have like burned out so much that they start making mistakes and they start doing things, and it doesn't reflect who they really have been as a clinician, right?
Yes.
But they didn't have the resources. And when we talk about mental health and we talk about taking care of yourself, whether it's financially or like just making sure you take your breaks and you put boundaries in, I think this is a great chance for early professionals to start to consider those things because it sneaks up on you.
Yes.
And then unfortunately, some of those people find themselves, like I said, with some challenges that end up at regulation.
Yes.
So that is really exciting.
Yes, I absolutely agree. And it is something that we also encourage that the PT, PTA schools encourage the students to explore this as well, because you're absolutely right. It's a skill that we're all better for, recognizing it and employing it, because there is a difference between incompetence, not being able to perform clinically, and discompetence, which is where those external pressures are affecting your ability to perform. And the ability to manage that and know where you are in that cycle for all of us is critical.
Absolutely. That's fantastic. I really appreciate it. Are there any other questions from the board regarding this? Okay. I
Hi.
was going to, yeah, I'm sorry.
Hi. I'm Nancy Bella. I'm Chair of the Quality Practice Committee and on the board of the California chapter. I would just like to tell you how much we appreciate the board does. And the Federation has been so aggressive over the years. I'm 60 years in the business as opposed to Karen is only 30. But I did learn something interesting at our recent call with the California chapter and with Mr. Kaiser. And I didn't realize that when the students got the announcement about passing, that it's really a temporary piece of information until the Federation has done all the checking on the testing at that particular time and whatever. And then the board is notified after you confirm that that really is their test result. But my experience is the student gets that information from you and they assume that they passed and that's the final, they don't know exactly what their score is, but it is the final decision. And I think they need to know that this is a temporary, piece of information and it will be documented or validated within a couple weeks or whatever that time frame is that I know that that board gets that information. But the student is confused and I have a niece and a granddaughter and myself, and I was chair of the program, an educational program, and I had no idea that that was a temporary piece of information. But thank you for all you do. I'm not complaining. I'm just saying, give a little more information to the students so they're not surprised when they get perhaps that they didn't pass.
Absolutely. And we don't want confusion. I know there've been a number of changes in the notification system recently. The intention is that the jurisdictions, the boards get the score information first, and then about a day later, it goes out to students. Occasionally, there may be a situation where they have to validate some of the exams after that. That should be the standard process, but I'll take your experiences back and make sure that we're hitting that mark and that folks aren't getting early information, because yes, that would be confusing. Yeah.
Okay. I think we've just opened for public comment. Thank you, Nancy.
Thank you.
Is
And I
there-
just want you to know that Tamika Island is going to respond to the number B on updating about the chapter. and
We'll
the
get
board.
right back to that one. Yes, when
Thank
she
you.
gets here. No
currently
problem.
Online.
No. Oh, okay.
So-
Great. Thank you.
Thank you again.
All right. So I think we can still do the rest of public comment for item 22A and C. Can we finish public comment for item 22A and C, which is the Federation State Board update, and DCA, who has already left, can take comment? Oh, we're still here. Sorry, missed you. Sorry about that. Okay, is there any public comment online for item 22A and C?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on these items, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, thank you. I will move on now. One moment. We're just going to see if we can do item 22B via WebEx presentation.
Moderator? If you can confirm that there's a Tamika Island online and open her mic, she can provide the CPTA update.
All right, this is the moderator. Believe I have them promoted now.
Good morning. Can everyone hear me?
We can?
Yes, thank you.
Good morning. Thank you for the opportunity to speak. I am Tamika Island, the Executive Associate with the California Physical Therapy Association. We appreciate the opportunity to speak this morning. We don't have any official updates or questions of the board. However, we would like to congratulate the Physical Therapy Board of California on a successful 2025 year, and we look forward to collaborating on consumer forward initiatives for 2026. I'm happy to answer any questions you may have for us.
Okay, thank you. Are there any questions or comments from the board? Okay, no. Any public comment or questions for this item 22B? Any public comment online?
This is the moderator for members of the public on WebEx. So if you would like to make a public comment on this item, please click the raise hand icon. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment on WebEx at this time.
Thank you very much. All right, we are going to move on to the next item on the agenda, and that is 21. 21. We're going to initiate a presentation of the use of physical therapy on animals. Council, did you have a few comments about the presentation?
Yeah, for those of you who don't know me, I'm Michael Knotes. I'm the general counsel for the board, and I know everyone is eager to do their presentations, and the board is eager to hear all that information. So even though I went to law school and I acquired this disability of having to talk really long about things that could be much shorter, I'll try to make this short. So just some brief sort of ground rules and expectations. Please respect everyone's opinions and be courteous. And also sort of just to confirm that these are informational presentations. I think you're going to get some great questions from our board members, but the board is not going to be discussing or debating these issues and won't be taking a position on pending legislation or the issue in general. Those debates and deliberation happen in the policy committees of the legislature, including, of course, here the business and profession committees of each legislature. So we do have a very full schedule today. So following the presentations, we will be, of course, taking public comment in the room and online. And for public comment on this topic, we're going to limit that to 5 minutes for each individual who'd like to make comment. So with that, I think we can get started.
Thank you. We are going to start with a presentation by Leslie Adrian, the Director of Professional Standards at the FSBPT. We're really thankful to have her. She has presented several times on different task forces impacting scope practice issues and has a lot of great information from across the U.S. and different states. Thank you so much for participating again.
Thanks for the invitation.
There's literally nothing worse than doing tech in front of everyone watching you. It's the worst.
Okay, so thank you again very much for the invitation to come back to present to your board. It is always wonderful for us to actually get in person with our members and to be able to help to share some information that we might have on a specific topic of interest to them. So I am glad to be here. I am going to place one very strong caveat on the presentation, and that is that I myself am not an authority on animal physical therapy. Although I hold a license as a physical therapist, this is not an area of practice that I have ever done or really been part of. So if you were to ask me very specific questions on, what do I do with this dog, I would say I have no idea. We'll, get into that a little bit more about training and, where this level of practice kind of lands around an entire scope. So, but that is one thing. If you did start asking me very specific questions about what do physical therapists do, in these types of cases, I really would have to say I don't feel comfortable speaking to that. So there are clinicians that would do a much better job and give you much better information than I can. Now, when it comes to the regulation of this area or the legislation in this area, that I feel like I have a pretty good background in because of working with the task force that we did with the Federation. So I would just want to keep those two things very separate with regard to my expertise and my knowledge. Okay, so we'll talk a little bit. I am mostly going to focus, like I said, on the animal rehabilitation, current statutes and regulations that are out there across the country. So when we look at state laws, there are 7 states that have specific language for animal physical therapy. And I am going to transition from the term animal rehab really to animal physical therapy, because I think that's really much more what this board obviously would be interested in. And as you'll see later, the task force came to really land on the term animal physical therapy. So that's where I'm going to go to, regardless of what these statutes or regulations do say in other states. So I'm going to bring Michelle back up. When we get to talking about Oregon specifically, it just doesn't make sense for me to talk about her laws and her regulations when she's sitting right behind me. So I will I want to welcome her to come back up. So, but when we look, there are exactly 7 states that have specific language for animal physical therapy. And those are Oregon, Nevada, Nebraska, New Hampshire, Wisconsin. And you find those regulations and statutes under the veterinary statutes and regulations. And they're written in a variety of different ways, but that's where they're found, is really under veterinary. And then in Oregon, you have it in the PT practice as well. New Hampshire has a very brief mention in their practice acts, which I'll show you later. And then when we look at PT statutes and regulations regarding animal physical therapy, you really find those in Colorado and Utah. So we're going to look first at the regulations and statutes that we find in veterinary. So I'm going to bring Michelle back up.
Hi again. The Michelle Sigmund Gaines, for the record, wearing my director of the Oregon Board of Physical Therapy hat in this instance. In Oregon, we have what I would describe as a coordinated approach to the regulation. And you can see that we have partnering statutes for the vet board and for the PT board. And in both instances, what it says is that a PT may practice under the referral from a veterinarian for treatment. The vet board does have an FAQ. That link is provided on this slide. Now, with that, when it comes to investigations, the vet board in Oregon would have regulatory authority to investigate and sanction if a healthcare practitioner didn't have a proper referral. So if a PT, even if they were trained in animal therapy, but they didn't follow that requirement, it would be considered unlicensed practice veterinary medicine in Oregon, which has both the administrative sanctions that you see here, and also would be considered a Class A misdemeanor. Now, if there was a proper referral, then the PT board would have primary jurisdiction over the practitioner. But because of the statutory language, the standards for care and for documentation are driven by veterinary medicine requirements for that continuity of care, if you will. And so we would partner with them to make sure we were clear on what those standards were and that they were following that. When it came to their ability, clinical skills, knowledge, and expertise, then that would, for animal physical therapy, that would fall under us. So what that means is that in theory, this would be a joint investigation. In Oregon, we have the capacity to share investigative confidential information to do those kinds of partnerships. And so that's how that would be executed. I will put this up, then this is how it cascades down into the PT board rule and how we reference back to those statutes. I just also want to note that this is the way the statutes have been written for at least 22 years. And in that time, the veterinary board has not had a complaint with regard to this practice. PT board, we have had one, but it was a confusion where the individual thought that there was not a referral. There, in fact, was a referral. And so there was no violation. The complaint did not go anywhere. So with that, I will turn it back over to Leslie for the next state.
Okay, thank you very much. Okay, so I had the pleasure of working on the task force. As I said, I'll talk about that a little bit later. But we had both the representative from the Nevada PT board as well as the representative from the veterinary board. The executive directors actually of both on our task force. So it was really, we got to learn a little bit more about Nevada than I think, and understand it a little bit better than some of the other states. But through the veterinary medical examiners, if a physical therapist wants to provide animal physical therapy, then they need to secure either a certificate, it's a certificate of registration to practice animal PT in the state, and they make that application to the veterinary board. And they do have some restrictions, as in having to have been an active PT in a U.S. jurisdiction for at least a year, and they must have had a Nevada PT license that's in good standing. So you're going to have your Nevada PT license first, and then you're going to make an application to the veterinary board to get this additional certificate of registration. So then you have with the veterinarian who's who the physical therapist is under, they are not required to supervise the PT directly during the animal physical therapy. And the veterinarian is also not liable for the acts or the omissions of the physical therapist. And talking with the Nevada vet board exec director, when she was explaining this to me, why this was important language, it has to do with a veterinary model of care, which it's kind of outside of our level of, our expertise, but they look at things basically, and actually somewhat analogous to like the PT is responsible for all the care that's provided, right? Whether it's provided by a PTA or by the PT is the one that's ultimately responsible. Well, the veterinary is the same thing. And they have that, I think it's even more broadly than what we have in physical therapy, where it's pretty much anyone that touches that animal that has any sort of chain linkage back to the veterinarian is the one who is responsible. So they felt that this language and any language in other states would be very important to say something about the liability of a veterinarian with regard to the animal PT and a physical therapist actually treating it. And we talk through this a lot. As a physical therapist is a licensed individual, someone who has a scope of practice, someone who has their own board to report to, that there really is a mechanism in order to hold them accountable. So this idea of animal physical therapy, it isn't new, right? Like Michelle just said, over 20 years, and the Nevada code reaches back over 20 years, but they all have in common that, sorry, I'm going to backtrack, but the fact that this has been going on a long time, it's not new. I feel like it's something that, oh, when we start talking about it or hearing about it, then we start to say, oh, this is a new area of practice. It's not necessarily new. It just as I think as PTs start to investigate more and more areas where they can have an impact, then we start to hear about different areas. So, but the states that have been doing this, most of them have in common is that they've been doing it for a while. So in Nevada, you have to successfully complete 100 hours of instruction or specific coursework or a combination of both in the animal physical therapy content area. And then they have other specific areas within that denoted in their regulation. And then in addition to these 100 hours of what you'd consider more didactic training, there's also 125 hours of supervised clinical experience that's required with a licensed veterinarian. Now we move to the state of Nebraska, and theirs is also found in the veterinary laws and regulations. I know for a fact because I spoke with the gentleman who worked with the state, but they came together really collaboratively as a PT board and the PT association and then veterinary board and their association to come up with the language for this, which is probably the best way to do these things, right? Is to really collaborate so that everyone interested are spoken aloud and that their concerns are heard and try to be dealt with on the front end. So what they talk about is an licensed animal therapist. And the reason that they use this term is because they aren't specifically going to restrict this to physical therapists. They also have it open to OTs. I believe it was also chiropractors and massage therapists, I think, that can end up getting this credential as a licensed animal therapist. And this is for an individual who is a profession other than veterinary medicine and surgery. So, and then they would have to meet the additional standards for training regarding the performance of that healthcare profession on animals. And then there's a whole rules and regulations that are written that's specific to this. And then they have to get a license as an animal an animal therapist by the department. So it's a whole different credential in addition to your PT credential. So you can kind of see the theme with both Nevada and Nebraska in the way that they do that. So again, they've laid out their training program, another 100 hours of didactic training, and then they have 40 hours of supervised clinical training. And they're also required that there have been a competency assessment performed. So one of the restrictions that they have is the things that, and I think this is we'd have to really read through the regulation or the statute to understand this clearly, but the treatment for animals is limited to your human scope of practice. So if you can't do it with the humans under your scope, then you can't do it with the animals under your scope. So, and like I said, it was a variety of different professions. So, PT, OT, chiro, massage therapists, and acupuncturists are all eligible to get this credential as an licensed animal therapist. And then there are requirements for additional continuing education. Okay, so we moved to New Hampshire. And originally, the information was found in the Physical Therapy Practice Act, and they defined the word animal physical therapist. And it is an individual who's licensed to practice physical therapy in New Hampshire and has obtained a certification to practice on animal physical therapists. So again, you need both. You need to you start with the PT license and then you find you get the additional certification. And then they went ahead and defined animal physical therapy. And then in rulemaking, or it talks about in rulemaking that they'll establish criteria for the initial and the renewal and reinstatement for certified animal physical therapists. Well, then you go and you look further and you see that that animal physical therapy certification used to be found in the PT Practice Act, but it was repealed from it. And now it is found in the Veterinary Practice Act. I don't have any background or information on why that was done. I just know that it was. And again, we'll make note that we're looking at something, in the early 2000s. So again, they've had the statutes and regulations in place for a while. So then I went to the Veterinary Practice Act to take a look. And again, the animal physical therapist and the animal physical therapy, those definitions remain pretty much the same. There's, again, the specification that the certification to practice animal physical therapy comes from the Board of Veterinary Medicine. And to get that certification, these are the regulations that come from, or excuse me, the statute that comes from the Veterinary Practice Act. And one of the things I want to make note of is that they do need to have a referral from the veterinarian. So I think we're pretty much 3 for 3 or 4 for on that when we looked at the current statutes and regulations. And then one other thing I want to say before I move on to Wisconsin is that my understanding is that the majority of treatment right now is really performed. It is not limited to, but the majority of treatment is really canines and equines. So dogs and horses. Those are the 2 biggest areas of practice. I do think that there are people that are doing other things with other animals, but those are really the 2 biggest areas. So Wisconsin comes at this a little bit differently. And again, this is found only in the veterinary statutes and laws, statutes and regulations. But when they talk about a veterinary referral to a license holder in another profession, so this isn't talking about using their vet techs or referring to another veterinarian, but it's very specific for another profession that's licensed in the state. And they call these things complementary, alternative, and integrative therapies. So CAIT, CAIT. And this is a group of preventative, diagnostic, and therapeutic philosophies and practices. And you might see, again, acupuncture, homeopathy, manipulative therapy, other manual therapies, which you see in osteopathy, chiropractics, physical medicine, and therapy. So I think that's where PT would really fit in this list. And the veterinarian has to make the referral to a client for treatment of a patient. So by client, I think they are referring to the other licensed practitioner. So, which is kind of weird because a lot of times we talk about patient client, or make a referral for the client, but it's referral to a client for the treatment of a patient by a license holder in another profession using these complementary, alternative, or integrative therapies. And the individual has to provide evidence to the veterinarian, so it's not to the board this time, it's to the actual veterinarian, that the type of therapy for which the referral is being made is basically that the license holder themselves is in current licensing and in good standing with the board in that state, and that license holder's education, training, and experience in performing the therapy on the animal. So they have additional training. Okay, so now we're going to go look at the couple of states where you're going to find this information more in the PT statutes versus the veterinary statutes. So the first one is Colorado, and they have an area, it's called Special Practice Authorities and Requirements, and it's specifically about the physical therapy of animals. And a PT can perform PT on animals when that therapy is consistent with the scope of practice of a physical therapist, and it's recognizing the special authority granted by this section. It shall not constitute the practice of veterinary medicine. So we want to make that clear. And then they also say, in recognition of the emerging field of physical therapy on animals, before a therapist can start working with an animal client, you have to have a veterinary medical referral, or veterinary medical clearance of the animal via veterinarian. So a medical clearance is a little different than a medical referral. So basically they say that the veterinarian would give their approval that the animal is healthy enough or it's appropriate to begin animal physical therapy. So, and again, there's 80 hours of didactic training and 120 hours of clinical education that's specific to animal physical therapy required. So when we look at Utah, this is the way that they have in their statute that they have written this out. So again, upon written referral by a licensed veterinarian, the practice of animal physical therapy can be completed by someone. They have to have had, again, 100 hours of didactic training, and they have specific requirements regarding anatomy and some hands-on training of the animals. And then going back to 2005, it places an exemption on to the Veterinary Practice Act that allows PTs to perform animal PT with a referral. And then in 2009, they amended the PT Practice Act to include animal physical therapy for both PTs and PTAs. This is the only state I know of that allows PTAs to actually be included in animal physical therapy. So this is specifically the law from the Utah PT statute. And it says that, again, that you can practice animal physical therapy if you have the 100 hours of training and education. And then they're going to break that down further. And then you will need to have additional continuing education. So staying with Utah, and talking about their physical therapist assistant, very similarly, a PT assistant may practice animal physical therapy within the scope of that PTA's practice if, again, they are under the on-site supervision or general supervision of a PT who has complied with all the requirements, and they also complete the additional training, the PTA themselves. So not just the PT, but the PTA themselves would also have to go through the training. And I do not know for you what their definition is of general supervision. So I don't know how loose that is. Okay. So we talk a little bit about public safety and disciplinary actions because, you know, it's always an important consideration for us. And I had a query done of the FSBPT exam licensure and disciplinary database, which is, I'm going to go ahead and put in a plug for why it's so important for all of our member jurisdictions to participate fully in our database, because when you all ask me questions about, is it safe to blah, 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 ... Well, this is the first place that I turn, is querying our database. And the better the quality of our information is, then the better answer I can give you. So we do thank all of the states who are participators and champions, and we would put California definitely in that list. So in the ELDD, there was one disciplinary action, and that was from Colorado. And it was actually it wasn't for harm, it was for unlicensed practice. So that person did not currently or ever hold a license to practice physical therapy on animals in the state of Colorado. And they were advertising for, and then they admitted to providing therapy and alternative healing techniques to animals in addition to humans since the mid-1990s. So they weren't licensed to provide that practice. To my knowledge, there was no other complaints regarding harm. I did not have any other instances in the database from any of those 7 states or other states that I was able to retrieve. And this was from the last, I asked for the last 10 years. So, I did go to the American Association of Veterinary State Boards. So it's basically the analogous organization to FSBPT. And I asked them, and they said, so PTs, because PTs have never taken the veterinary medical exam and that they don't have a veterinary license, they aren't tracked in their database. So I would have to do a state-by-state disciplinary search of the veterinary boards to see if there had been complaints, and then how they had handled those complaints, whether or not, you know, they had then maybe referred them to the PT board. I can only say I know that the PT boards that I know of, you know, from the ELDD, that have not had any besides that one in Colorado. So that would be information that we could do a deeper dive on, or could reach out to veterinary boards one by one. There's only the 7. but when I got this information, I didn't have time to reach out and get the information back. So I did, because I had that relationship with the administrator in Nevada. I reached out to her. She said they have had one disciplinary action in the last 5 years for a PT. And again, it was unlicensed practice. And then they ended up, once that person basically was educated on what they needed to do, they did give them a probationary license moving forward. So, and the Wisconsin Physical Therapy Board has had no disciplinary actions, which I didn't expect they would. I did get confirmation from one of the board members. I didn't expect they would, because we didn't have it in the licensure and disciplinary database at FSBPT. So again, I think it's somewhat of a picture. It's not a full picture, because we really need to go to the veterinary state boards. But to give you an idea, I don't think there is a rampant number of complaints against PTs who are providing physical therapy to the animal. But again, that would be much more of an assumption and a leap, because I did not do the dive into all of the state's veterinary boards. Okay, so when we started asking ourselves, where do some of the associations and the national organizations kind of land on this? And we look at APTA, and again, APTA is by far the largest professional organization of physical therapists and physical therapist assistants. And they have a House of Delegates policy regarding collaborative relationships between physical therapists and veterinarians. And they support this collaborative relationships and the evolution of specialized practice by PTs who are addressing the rehabilitation needs of animals. And they state, where allowable by state law and regulation and consistent with the PT's knowledge and skills, they may establish collaborative collegial relationships with veterinarians for the purposes of providing professional consultation and expertise in movement impairments, fitness, and conditioning for animals. And I do think this is a great place to take a pause. As I was learning more about this, there are a number of animal athletes. So I know it's kind of like weird, or a different concept to think of, but there are some high performing, high level animal athletes, whether it's in, from the tip of the top pyramid, when we look at like these thoroughbred racehorses, right, who are for sure animal athletes, to some of those, the dogs that do like the agility courses and stuff, and their abilities to stop and start and change direction and do all these things. I mean, and it takes, everything working with them the same way as it does. They train like human athletes. They need to rehab like human athletes. So it's kind of an interesting world and just a different way of looking at it. And then also, as the American relationship with their pets really has evolved and changed, truthfully, perhaps things that when a veterinarian tells you that your animal needs to have surgery on X, Y, and Z, perhaps in the past, that would have been kind of a deal breaker for the animal and for the owner. A lot of times now it is not. So if your animal, and with improved techniques in veterinary medicine, so if your animal has a torn ACL, which I've known a number of puppy dogs who have, they ended up having the surgery to repair it. And then in order to go back to their highest level of function, they actually did receive rehab afterwards. So super interesting. The APTA also has a special interest group. It's been around since 1998 that is specific to animal physical therapy. And this is the official organization recognized by the Academy of Orthopedic Physical Therapy. So the SIG, the special interest group, the SIG as it's known, they have done a lot of work to create standards of clinical practice, and that is published on their website. And it's based on a formal practice analysis of animal physical therapy. So it's probably a very good source of information if the board were going to, want to understand better what you need to do for, in order to practice at a high clinical standard. Okay, and we'll talk a little bit about the Federation. So there was a member of the Ethics and Legislation Committee who is a nationally renowned and known for his work with animal physical therapy. And he was on the Ethics and Legislation Committee at the time when we were doing a review of the Model Physical Therapy Practice Act. So his voice was definitely heard when we were going over certain areas of practice and ways to really improve the Model Practice Act, the MPA, so when we looked at the regulation of physical therapy, and he really truthfully was pushing much harder for a strong statement of this is part of the practice of physical therapy. At that time, the committee who does the first round of revisions and review prior to sending it to the FSBPT Board of Directors for their approval and then publishing, felt that that was they weren't comfortable doing that because this is not an entry level area of practice. So the MPA is really supposed to guide what is capable of a person getting out of school, right? Like this is the Practice Act that we would like to see used as the gold standard from all of our members and all of the state boards. And this is an area of practice that wasn't yet established for an individual, a new graduate, unless they'd had some really significant training in it as you know, during their student days. So we wanted to make sure also though, that we didn't do anything that we, the committee and the Federation, wouldn't do anything that would not allow PTs who had been appropriately trained in order to do this. So that's where they landed on the language that's in the Model Practice Act now, which is nothing in this act shall prohibit a licensee from providing physical therapy to animals for which the licensee has completed the education and training as further established by rule. So basically saying, we see you out there. We know that this is being done. We know that this is an area of practice for some folks. We know that it's not for everybody, and we know that you need additional license and training. So this is where they landed. So as part of the Model Practice Act, if you've never read it, which I would encourage you to do so, first you have the law, and that's about 4 pages. But then going on for many pages is a commentary, which explains every section of the law and gives a little bit more in depth to the thinking of the committee as to when they were going through this area and the Federation with regard to every area of the law. So when we look at the commentary with regard to that exemption, they state that the practice of physical therapy continues to evolve, including the treatment of animals. And while there's currently no consistent standard of specific education and training, it's appropriate to note that additional rule development in a jurisdiction can address those minimum standards to demonstrate competency to provide physical therapy to animals. Which brings us to the task force that was from this year and earlier this year. Now that there was some backbone of a statute from which to work off of, and there were no, however, regulations. So the statute, the Model Practice Act, referred to regulations and rules. However, there were no model or any examples out there. So that was what the Animal Rehab Task Force was created to do, is to draft model regulation language. So, and it was really at the request of our membership to provide resources for jurisdictions that are interested in animal physical therapy. And their charge was to draft those model regulations regarding animal PT. And here's where it was hard, right? Like, you guys, the statute is given to you, and then you promulgate the rules from the statute, right? So when you try to create model regulations, but you don't have a statute to really work from, it was kind of a stumbling block in the beginning for the task force, right? We were like, okay, what are we really drafting from? There wasn't a statute to refer back to. So, and we had to make the assumption that statutory authority exists in the Current Practice Act to allow PTs to provide care for animals. So either in the veterinary, some act somewhere, you you had the statutory authority to do this. So since there really isn't a model law rather than the exemption language from the Model Practice Act, that's really where we as a task force had to start, kind of using that, okay, well, we're going to draft from here because they're, again, all, and so many as you saw, the statutes that do exist are different and vary enough where there really wasn't a model to start from there either. So, and when we put this out, the recommendations, we did have to say, okay, one of the things that we're assuming first and foremost is that you have the statutory authority in your state, and that's why these rules and regulations are going to be of use to you. But that's really the first place to start if that doesn't exist. So it did land, as I said, the preferred term is animal physical therapy. And then they have the definition for that. And then the access to care, this is a sticky issue. So you need to consider access levels that you have for human care versus animal physical therapy care. Should those be different? Should they be the same? Why? So when we're talking about things like direct access versus the need for referral versus the need for, medical clearance. And, I think it's just a consideration for boards as they look at this area and they say, okay, we have this standard for, one group of clients and patients and potentially a different standard, and just be able to back up whatever that decision is. So I'm not going to tell you what your decision should be. I'm just going to say you should probably consider it and understand and look and say thoughtfully, why are we doing one versus the other or the same? And then looking at competencies, the state really does need to adopt educational competencies related to the practice of animal physical therapy, because like we said, this is not entry-level care. This is something that maybe students might hear about as a potential area to go into after they get their license, but this is not something that the schools are spending time on right now. So the qualifications from the model regulations to practice animal physical therapy, an individual must hold a current license as a physical therapist and successfully complete board-approved educational competencies regarding the performance of physical therapy on animals. And then when we look at those standards and competencies, the board-approved educational competencies must meet the following criteria. The content must be directly related to the practice of animal physical therapy. The instructors must be qualified by education, training, or experience. And then again, 100 hours of didactic instruction, which must include those list of things. So animal behavior, animal restraint, zoonotic and infectious diseases, the comparative anatomy and physiology of animals, pain recognition in animals, because that is very different than it is for humans, animal comparative biomechanics, common neuro and orthopedic conditions in animals, and evaluation of the animal patient. And in addition to that, a minimum of 40 hours of supervised clinical experience under the supervision of a licensed physical therapist with experience in animal physical therapy or a licensed veterinarian. And the task force went back and forth on who an appropriate supervisor would be. And one of the things they were saying is that you could have a licensed veterinarian who honestly, you may not get much information from them about the actual animal PT or animal rehab part. That's not their area of expertise or what they really do. So you might be able to get you would be able to get the animal handling or the pain or some of the information about the common diseases. But with regards truthfully to that hands-on treatment, you wouldn't necessarily get that. The veterinarian may not be the best place to get that. So that's why they wanted a couple of options for that. And then there should be a competency assessment or final evaluation required as part of that training. Not necessarily developed by the board, but the training program that they go through needs to demonstrate that there is a competency assessment or some type of final evaluation. And then you as a board may require them to show that to you. That's up to you. So obviously, as you would go into this further. So when we talk about patient-client care management, and when you hearken back to the Model Practice Act, it always talks about patients and clients. It doesn't specifically say humans or individuals, as individuals has in the past really been taken to mean humans. So that was another thing that was not done as part of the last revision. However, it was something that we did call out to say, this does broaden who could potentially be a receiver of physical therapy services. So versus being more narrow, which a lot of states, that's the first place they have to start, is just look at their statute and say, oh, this says we can only treat humans. So, and right there, it's kind of a deal breaker for you. So with regard to patient-client care management, again, going back to that veterinarian practice ethos, there needs to be some sort of statement that the PT is fully responsible for all aspects of that physical therapy care provided to the animal patient or client, and that the veterinarian that's providing referrals or medical clearance, they are not responsible for the PT services that are delivered under this regulation. And another, to make it very clear that the performance of animal physical therapy with regard to that regulation does not constitute the practice of veterinary medicine. You know, a bit of a CYA statement, really. So the considerations that I think that state boards really need at this time as it relates to animal physical therapy are the clarity of your laws and regulations regarding animal PT. What does both the Vet Act and the PT Practice Act say? So at this time, as you guys saw, the majority of statutes and regulations are found in veterinary practice acts. And then addressing that question of individual versus human versus client versus patient, and making sure that your laws are clear regarding, you know, whether or not you can actually work with an animal patient or client. And when it comes to veterinary referral and or medical clearance, at this time, all laws and regulations are requiring some sort of veterinarian referral or medical clearance. So I haven't found all 7 of those states that we went through. It was very clear. And this is not entry-level practice. I've said it once and I'll say it again. There is no accrediting body for animal physical therapy post-grad education. There are no specific standards for what an education program should look like or is. So there is no national certifying body that says you are now an animal physical therapist because you have gone through this particular program. You do have those standards of clinical practice that were written by the SIG, but there aren't any training requirements. So when you look at education and training being one of those areas that a board is very concerned with, that's something to keep in mind. And then finally, in this situation, the animal is the public. So asking yourself, what's your comfort level determining the health and safety of your public? So if you have questions at this time, I'm happy to address them. That is everything that I had to bring to you today.
Thank you so much, Leslie. That was really thorough. And the task force had started this year, 2025.
Yes,
And it concluded this year.
It did.
Okay.
Yeah.
And do they have plans to continue with any second or follow-up?
At this time, there has been no direction from the FSBPT board to continue anything more with this task force. So they had a very discrete charge, which was to create these model regulations. They completed that charge. They are now published on the FSBPT members only site. So they're available to our members as a resource.
Okay.
And it was also presented at both the Leadership Issues Forum meeting as well as the annual education meeting.
Okay. Thank you. Are there any questions or
Hi. Of the states that you went through, which board between the PT board and the vet board is responsible for discipline for someone who is providing animal physical therapy. It sounds like in Oregon, it's a joint venture. And then some of the other states where the authorities in the Veterinary Practice Act, I presume that that is with the vet board, but do you?
So in Nevada, it would be with the vet board because they have that very specific extra certification, and that is given to them through the vet board. So I think it's in both Colorado and Utah, because those are specifically in the PT statute, it would be the PT board. And Nebraska, also the credential is given by the veterinary board.
Okay.
So
And I saw that in Colorado, it's a registration, but it's a different sort of license type. I know it's not a full license. That's
Exactly.
issued by the PT board.
Exactly.
Thank you.
And pretty much across the board, I've seen it really looks like the trend is that there is some type of additional credential that is given in addition to the PT credential. In Utah, that's not the case, but in the majority of others, there is this additional credential. And I think that's to be able to say, okay, you can be a PT because you've done all the PT stuff, but in order to treat this level of client, then you need to have these specific requirements. And if something were to go wrong in that realm of practice, then that credential could be removed versus removing the entire PT license also. So I think it was to give, be more specific.
That makes sense. Okay, I have two questions. The first one was, there was nothing in there. I know you mentioned the majority is canine and equine, but there's nothing in there regarding species-specific practice, like in terms of like, okay, this is your scope inside of this specialty or subspecialty. Do you know why there isn't? I mean, even to the level of, like you said, the registration or certification should actually probably say which species you're covering.
Sure. So I think I'd like to think of this very much the same way as we think of PT, right? While I was practicing, actively clinically practicing, for the most part, I was doing outpatient orthopedics, right? With adults or at least teenagers, right? Although my license said I could have worked with any age group and do anything, right? I could have gone and treated neuro. I could have done spinal, worked with patients that had spinal cord injuries. I could have done pediatrics. I didn't do any of those things because my personal scope of practice didn't allow me to. And my license still held me to that professional responsibility. So I very much think of it as the same way, right? Like individuals may come in and out of what they decide to treat. I know a lot of them do specialize on certain animals, but like the gentleman that I was talking about earlier, he works both with canines and equines, and he has training in both. And his professional, he feels that his personal scope of practice, allows for that. And again, there are ways that he can be held accountable if he were to harm an animal. And if it were to be found that he didn't ever have any training that was appropriate for him to be working with equines, then he could be held accountable for that the same way that if at that point I, decided to, pick up pediatrics and do some, PRN work at the local school district when I really had no business doing so if something had gone wrong.
And may I just add, that's an interesting question about species specific practice, but in the California Veterinary Practice Act, there is a definition of animal that is, and I don't have it in front of me, excuse me, but it's something to the effect of all species of the animal kingdom with the exception of humans. It uses the words animal kingdom. So in veterinary practice, there is no species by species
Definite or separate.
There's certain, I'm sure there's certain education that you need for each, but there's no separate license or variation between species in veterinary practice.
Makes sense. I also noticed that on the task force information, it indicated the responsibility of the physical therapy interventions should sit squarely under the role of the PT. but it doesn't say anything about supervision levels. Is there a reason why the task force didn't put any information about supervision levels in there?
I think that at this time, as it's not an entry level area of practice, I think truthfully, the task force was a bit skittish about what physical therapist assistant's role should be. And there isn't a lot of data on that, as there's only the one state that allows it at this time, which is Utah. So I think it was definitely an omission, but I think it was a question mark at this time. Where do we really go with it?
That's for physical therapy assistants. What
Mhm.
about the supervision issues from vet to PT?
Mm,
Because some of the states,
yes. So
like Colorado.
yeah, yes. Sorry, I didn't
okay.
understand what
It's
you were
okay.
saying. So,
Yeah,
once the referral is made, it's a similar type of relationship as it would be to a physician making a referral to a physical therapist, right? And you should have professional communication, but not necessarily a supervisory role in that care that's provided. So again, professional collaboration, and really professional communication at the same level. But I think we should think about it similarly to a physician referring a human patient to a PT and what we expect in that relationship.
okay. And kind of maybe connected to the issue you mentioned about direct access, the differences between states, and do we consider it separate
Mhm.
in terms of how do we handle this group versus this
Mhm.
group?
I didn't find in any of the states, in the states that I had talked to also, there isn't a supervision requirement of, even with a referral, right? Like you can even go back. So levels of access of care for human patients. You can have some states that allow direct access where a patient can go to a PT without any sort of physician referral first. And then you have other states where you can't do that, or you can do it on a limited time frame, right? So kind of those are the three areas. But none of those, once you're referred, do you then have to be supervised by a physician, right? In order to provide that care. You are, there is an expectation of exactly what I said, professional communication and feedback and discussing, with that person when you need to, right? And really an obligation to refer out then if you are referred a patient that's not appropriate for you or appropriate again for your personal scope of practice, that is an obligation, obviously, oftentimes a legal obligation within a statute requiring you to refer out if you can't handle that. So I like to think of it similar ways for that veterinarian refers out to the physical therapist. They give them the referral or the medical clearance. The patient then, that animal patient then goes and becomes the responsibility of that animal physical therapist. And that physical therapist should be communicating back to the veterinarian. And that is also one of the things I've heard a lot. This is a smaller world, really. And that folks, PTs that are out there doing this right now tend to have very strong relationships with the veterinarians that are referring back to them, and that they've built these collaborative relationships. They have a mutual level of trust and respect for each other and what each does.
Thank you so much. Any other questions right now from the board?
Oh, Leslie, very nice presentation, very illuminating. Thank you.
I'm going to bring that.
I want it to be in my face. Space of animal rehab or physical therapy is definitely new to me. If you don't mind, can you clarify one more time, what are the differences between the two states, Colorado and Utah? You said it's PT statute versus the rest of the states. That's my number one. And then the second question to me is like human physical therapy. So we as PTs can make diagnosis. Is that something that's been covered by this forced task? Who makes the diagnosis? Is it the veterinary, or does it again depend on where the PT or the veterinary statute is in place?
So even in Colorado and Utah, there is at minimum a medical clearance that's required by the veterinarian. And then in Utah, they require a referral. So I think for the most part, the medical diagnosis of the disease or the condition is going to be done by the veterinarian and communicated to the physical therapist. And then I think the physical therapist is going to look, and they're really going to look at the movement impairments, and very similar. There's
And one other quick question: what do they do in Europe? How is this all governed in Europe?
I do not have the answer to
I
that.
don't know.
I don't know. But I do know that there have been textbooks written that actually started in Europe prior to really the United States becoming involved in the care of animals. So those are some of the background textbooks that have been used. And I know that some folks here have trained with individuals from Europe. So I know it's being done. I don't know specifics.
And I'm asking that because I personally I attended a congress on a different topic, international fascial congress in New Orleans, and there were a lot of therapists, physical therapists who are animal physical therapists who came from Europe, and they wanted to learn how to use, their manual skills in terms of fascia with that, seemed like they definitely occupied quite a bit of space, at least in Europe. But thank you.
Okay, if there are no other questions from the board, we're going to move on to the second part of the presentation. Thank you so much, Leslie, for representing FSBPT and the task force. We're going on to the Animal Physical Therapy Coalition, APTC, represented by Karen Atlas and Dr. Mo.
Madam President, not to interfere, it might be a good time for us to just do a quick bio break, 5
We need a
minutes,
bio
and then I
break.
need to get some
apologies,
clarity
ladies.
on.
I guess I'm just a robot. I don't even.
I teach.
I'm so sorry. Okay, let's take a 10-minute break. 10-minute. Thank you. Hello, welcome back. We have a busy morning and afternoon. Thank you so much again for joining the PT Board of California. We are continuing on in presentation agenda item number 21B. We've invited Animal Physical Therapy Coalition to come forward, represented by Karen Atlas, and I believe Dr. Mo. As a point of order, we're taking public comment at the end of all three presentations.
Juggle two computers here. Good morning, President Brandon and members of the Physical Therapy Board and Executive Officer Jason Kaiser. Thank you for the opportunity to present today. My name is Karen Atlas, and I serve as the president of the Animal Physical Therapy Coalition. I'm a California practicing licensed physical therapist for nearly 30 years. And for almost 2 decades, I've treated animal patients under veterinary direction. For the purpose of today's discussion, it's to share a clear overview of where California stands, the structural issues that have persisted for more than 20 years, and why now, through the Sunset Review process, the PTBC has an opportunity to help resolve this regulatory conundrum in a way that protects consumers, gives them the access to care they are seeking, maintains veterinary authority and supervision, and aligns with the profession of physical therapy nationwide. Today, I'll walk you through 4 core objectives. First, to clarify the 20+ regulatory conundrum that has prevented safe and lawful animal physical therapy practice in California. Second, to explain why previous approaches, particularly those attempted under the Veterinary Medical Board, have failed. Not because of lack of need or lack of safety, but because of structural and statutory limitations and mismatches. Third, to present a cost-effective, practical, public protection-oriented framework that reflects national standards, and California can align with easily. And fourth, to highlight the PTBC's critical role in the upcoming 2026 Sunset Review, which is the appropriate vehicle for recommending statutory clarity. My goal today is not to tell the board what to do, but to provide the clarity and information needed to help you confidently participate in shaping a solution for California. Thank you. Who comprises the APTC? It's almost easier to say who isn't represented by the APTC. The Animal Physical Therapy Coalition is a large multi-stakeholder coalition representing all corners of the animal care ecosystem. Our supporters include veterinarians, physical therapists, registered veterinary technicians, working dog handlers in law enforcement and search and rescue, agility and sporting dog communities, animal welfare organizations, and thousands of consumers. Good. So do I ask the moderator to advance?
Just say next slide.
Okay, next slide. It's important to emphasize that many veterinarians are asking for change. They report months-long wait lists, especially for postoperative and neurologic cases requiring rehabilitation where timely care is essential for quality of life and maximizing outcomes. They express a strong desire to refer or provide a medical clearance to PTs who possesses the requisite training, but their Practice Act limits them from doing so. They consistently tell us they want to collaborate, not in a hierarchical sense, but in a more interprofessional sense. Many do not align with the position of their own trade association, the CVMA, on this issue, who stands firm on requiring direct supervision of any non-vet professional, regardless of education. The veterinarians of the APTC value the One Health approach, embraced nationally, an integrated model that recognizes the importance of interdisciplinary care teams to improve patient outcomes across species. Next slide, please. California has multiple statutory restrictions that have created the long-standing regulatory gap. First, physical therapists are legally limited to treating humans only, even with extensive animal rehabilitation training. So when a licensed physical therapy is working on an animal, they are doing so as an unlicensed veterinary assistant in the eyes of the law. Second, veterinarians are limited to referring only to other veterinarians, even when a PT may be the most appropriate rehabilitation provider. This leads to the consequences that we see today. Because qualified PTs are not named as legitimate providers of rehab services, they have a restraint on their trade and limits their opportunities to earn a living. And consumers, despite their plea and demands for more access, continue to face barriers to rehab care for their pet. And then veterinarians lack the authority to refer outside their own profession and have their hands tied despite their desire to work interprofessionally with PTs for the benefit of their animal patients. These constraints do not align with the way modern interdisciplinary rehabilitation care should be delivered. Next slide, please. Now I want to take a moment to explain why legislation and regulation are needed now more than ever. In 2022, the CVMB enacted highly controversial regulations with large consumer outpouring of opposition that were intended to clarify roles, but in practice, they actually reduced access and placed additional burdens on physical therapists, who are, of course, unlicensed assistants working with animals. What this did was to further solidify an animal healthcare monopoly by restricting who could provide rehabilitation even when that person was highly trained and operating fully under veterinary direction. Without the authority to regulate another licensed professional, the VMB could not add licensed PTs into their act as legitimate providers of service. So here's why a statutory fix is necessary. First, legislation ensures that only qualified physical therapists, those with the appropriate training in animal PT, are authorized to provide rehabilitation. This is the clearest and most effective way to protect the public from untrained individuals who may represent themselves as rehab providers. Second, it allows us to clearly define the roles of the PT and the veterinarian. Both practice acts would need updates, though. The Veterinary Practice Act must explicitly authorize veterinarians to provide medical clearance or a referral and determine the diagnosis and the supervision levels of the PT. And the Physical Therapy Practice Act must clearly recognize animal PT as within the PT scope when those conditions of veterinary supervision and medical clearance have been met. Those changes create clarity for everyone, for vets, PTs, consumers, and the regulators. Third, establishing this framework creates transparent complaint pathways and accountability. When consumers know exactly who is responsible for what and which board oversees which part of the care, enforcement becomes clear and much more effective. Fourth, statutory clarity removes longstanding barriers to employment and licensure. And finally, legislation increases safe access to animal health care options for consumers. So when we talk about legislation being necessary, what we really mean is clarity protects the public, it empowers the veterinarians, it enables PTs to practice safely within their competencies, and ensures that California families and their animals finally have access to care that they need. Next slide, please. Across the country, two regulatory models are used for animal PT. The Veterinary Medical Board-led models, such as Nevada, and the PT Board-led models, such as Colorado and Utah. And of course, there's overlap. The goal is not to adopt another state's model verbatim, but to identify the structure that best fits California's existing regulatory framework, minimizes costs, and aligns appropriately with professional competencies. Next slide, please. In 2025, the Federation of State Boards of Physical Therapy updated its Model Practice Act to explicitly include animal physical therapy within the practice of PT. It specifies that PTs may treat animals when they have appropriate training and when a veterinary provides the diagnosis. This represents national regulatory consensus. The work to define competencies is already done. There is no need for PTBC or anyone else to create or administer additional exams because the certification programs already provide them. Next slide, please. Now, I'd like to walk you through some key historical touch points that help explain how we arrived at the current regulatory conundrum and why it has persisted and actually it's worsened. Back in 2016, during the Veterinary Medical Board's Sunset Review, this issue was formally raised and the legislature instructed the VMB to work with stakeholders to resolve it. In response, the VMB created a 17-member stakeholders task force composed of veterinarians, PTs, RVTs, public members, and trade associations. Over the course of nearly a year of meetings, this group worked collaboratively and ultimately reached consensus language that everyone agreed on. It was actually a bit funny. At the time, Dr. Mark Nunez, the president of the VMB and the chair of the Stakeholders Task Force, said jokingly, "I don't think they investigated what happened in Benghazi as much as what we have investigated in animal rehabilitation." So you can trust us that we dove deep. So that consensus language, finalized on February 2nd, 2017, allowed California licensed PTs with advanced certification in animal physical rehabilitation to provide rehab under the level of veterinary supervision determined by the veterinarian, whether that's on-site, off-site, or in a range setting. However, when that consensus language went back to the VMB, the board rejected it and rewrote it. In April 2017, the VMB inserted a requirement for direct supervision only, which is significantly more restrictive than the consensus language, which included the option for an indirect supervision model. So they took the indirect supervision away. Then in July 2017, the VMB took another step and approved a motion that stated veterinary assistants may provide animal physical rehabilitation under the direct supervision of a veterinarian. So what does that mean in practice? It resulted in a situation where licensed physical therapists with master's and doctoral degrees and extensive experience would be required to complete more training than an unlicensed veterinary assistant with no training at all to perform the same task. That outcome exposed two things. It was never about safety. It exposed the VMB's bias against physical therapists. It strengthened the vet monopoly on animal rehab and drives most qualified PTs out of the field altogether. The vet board changed the goalposts midstream, and notably, it is a woman-owned small business women-owned small businesses that are affected the most. Women make up the majority of practitioners and entrepreneurs in this field. I'm one of them. Secondly, it exposed a fundamental misunderstanding of PT competencies and how interprofessional collaboration how it actually works. Next slide, please. California has attempted twice to regulate animal PT under the VMB framework. AB 3013 in 2018 and AB 814 in 2023. Both efforts attempted to codify the original VMB Stakeholders Task Force language developed in 2017. Both efforts failed. The failures were not about need nor about safety concerns. They were fundamentally about a structural mismatch. Next slide, please. The VMB regulatory structure simply does not align with PT licensure or PT clinical practice. This misalignment led to inflated assumptions to account for a new licensing category, new examination development, new premise permits, new inspection infrastructure. It expanded enforcement responsibilities, and it needed more additional staff hirings for the enforcement. These assumptions drove really high projected costs. By contrast, the PTBC has demonstrated through the EMG specialty regulations that it can successfully regulate a PT specialty within existing resources. For cost reasons alone, but also competency alignment, animal PT belongs under PTBC oversight. Next slide, please. A simple but critical principle: physical therapy is not medicine. Veterinary medicine is not physical therapy. They are separately codified professions within their own regulatory board. PTs do not diagnose disease. They don't prescribe medications or perform surgery. PTs are not looking to practice veterinary medicine. They are wanting to practice their specialty within a reasonable regulatory framework. This distinction that animal PT is not the practice of veterinary medicine is essential for regulatory clarity. Next slide, please. Animal PT fits naturally and cleanly within the physical therapy board's existing structure. Like EMG, animal PT is a specialty requiring advanced training. It does not require the creation of new licensing categories. It doesn't require new premise permit systems. It doesn't require new state resources. It does not require the PTBC to develop or administer an exam. This is a low burden, high clarity regulatory fit. Next slide, please. We now have more than over 100 cumulative years of animal PT practice across states where it is board regulated. When you combine Colorado, Utah, Nebraska, Nevada, New Hampshire, Oregon, and across that entire span, there have been 0 documented cases of harm from qualified PTs, 0 public protection failures, 0 disciplinary actions, 0 malpractice trends. Animal PT is low risk. And when patients or consumers have concerns, they do file complaints. So we should know by now if harm has existed, and we haven't seen that. Next slide, please. A veterinary premise permit is designated to regulate activities such as surgery, anesthesia, radiology, controlled substances. Animal PT involves none of these activities. Low-risk animal services like grooming, training, massage, fitness operate under local animal ordinances. PTBC already has facility inspection authority. Adding a VMB premise permit would introduce significant costs without improving safety. California already has appropriate county level pathways for low-risk animal care facilities. Next slide. Colorado's model is one of the longest running frameworks, and as a result, they have seen a flourishing animal rehab market. Created through PT and vet collaboration in 2007, it places animal PT within the PT Practice Act. It requires veterinary medical clearance.
It requires specialized education and supervised clinical training. It maintains a public registry of qualified providers. It uses collaborative complaint review with veterinary input. Has operated for nearly 18 years without a single complaint of harm. It's simple, safe, and efficient. Next slide. The Utah licensing bureaus for both PT and veterinary medicine report no disciplinary actions against PTs, no cost impact to their state, no operational burdens, no concerns from the veterinary board. Both professions occasionally needed an educational review about exemptions and allowances, but the regulatory model is cooperative and it's stable. This again demonstrates that PT-based oversight is a low-burden, high-clarity solution. Utah enforces what Colorado already showed. A PT-based model works. Next slide, please. So there's a practical regulatory choice here. With option one, you had the VMB model, which showed us a high cost, a structurally mismatched approach with 20-year record of inability to resolve the issue. And then we have option two, which is the PTBC model approach, which is a low cost, competence aligned, nationally proven approach that could integrate smoothly into existing PT regulatory structures. When viewed through the lenses of safety, cost, statutory fit, and public protection, the PTBC model emerges as the most practical and sustainable choice. Next slide. A simplified workable statutory framework for California should include the veterinary diagnosis and medical clearance or referral, a supervision level determined by the veterinarian, whether that be direct or indirect. And those indirect and direct supervision definitions are already in the Vet Practice Act, and they fit nicely for this as well. So that would not need to change. We could just keep the supervision level definitions the same and just allow the veterinarian to make the decision on whether a direct or indirect supervision is most appropriate for any given animal. A PTBC maintained registry of trained providers would be helpful and collaborative complaint reviews with the PTBC retaining authority. Authority for PTs to directly supervise aides is also needed, consistent with the VMB's regulations, where the DVM can directly supervise an unlicensed person for APR. Permission for animal PTs to work in a variety of settings like vet hospitals, rehab clinics, mobile practices, and ranches. Access is critical, so we need to be able to allow for those different settings. This framework preserves veterinary medical authority while allowing trained PTs to practice their specialty to effectively increase access to care for animals. Next slide, please. This model protects the public by ensuring only qualified providers offer animal PT, maintaining veterinary oversight through diagnosis and supervision. It protects them by providing transparent, accessible complaint pathways. It reduces unregulated and untrained care. It would expand access for animals, for families and animals. And it would clarify liability. Insurers already cover animal PT in states where clear statutes have already been made. And most importantly, it ensures that California consumers receive safe, competent, and more accessible care for their pet. Next slide, please. This approach is supported widely by board-certified veterinary specialists, general practice veterinarians, major animal welfare and rescue organizations, law enforcement and search and rescue handlers, PT leaders at both the state and national levels, and a very, very large consumer base. The alignment is extensive. Next slide, please. And what if nothing changes? If California does not act, wait lists will remain long. Animals will continue going without essential rehab services. Qualified PTs will remain unable to practice. Consumers will increasingly turn to untrained providers. Regulatory agencies will continue receiving misdirected complaints. Both boards will continue revisiting the same unresolved questions, and California will fall further behind national standards. Next slide, please. To close, animal physical therapy is physical therapy. It's not veterinary medicine. The PTBC is the logical and competent regulator of the PT elements in this specialty. Both practice acts need statutory adjustments. The EMG specialty provides a clear blueprint. California can modernize safely, cost-effectively, and in full alignment with national standards. Multiple states have already done this successfully, and California is now positioned to join them. Next slide, please. The 2026 Sunset Review provides a meaningful opportunity for this board to help resolve a 20-year regulatory conundrum, recommend statutory authority that aligns with PT competencies, improve access to care for California's public and their animals, support qualified licensees in employment and entrepreneurship, reduce unnecessary regulatory burdens, and establish PTBC as a leader in modernizing interprofessional care for animals. Next slide, please. Thank you for your attention, your thoughtful consideration, and your dedication to public protection and improving their access to essential care. I welcome any questions you may have.
Thank you, Karen. Are there any questions from the board?
Thank you so much. Very informational. What is the mechanism for continuing competency within this?
The continuing competency in the other states have folded into their requirements of, requiring all of the subject matter competencies. And they've also included a certain amount of hours to have been done in animal rehabilitation. So they changed that in their Practice Act to add X amount of hours in addition to, or that their original number of Con Ed hours need to, this number of hours needs to be part of your larger Con Ed hours, so that there is some responsibility of continuing learning.
Thank you.
Are there any other questions from the board?
Thank you. Dr. Atlas, right?
Just Karen.
Karen, thank you so much.
I'm just a Karen.
Again, very, very illuminating and informative. My question is, from your perspective, what is the ask from the board? Where's the one obstacle that you think, needs to happen in order for that one domino?
We have met in the past is that the board was perhaps not recognizing that animal physical therapy was the practice of physical therapy. It had been mentioned before by Mr. Kaiser, actually in the Senate informational hearing back in August, that he believed it should be in the Veterinary Practice Act and that it should belong there and housed there. So it hasn't, my opinion is that it should, especially with everything that has gone on. This is just a little piece of what's been going on for the past 20 years. That this body here should be the ones regulating us.
And just to further answer your question, this would all require legislative change.
Yes.
So that is however the legislature wants to handle this or not. It's up to the legislature.
So in Sunset Review, you have the opportunity to ask the legislature for help in certain areas. So if it's brought up to the legislature and say, hey, is it possible that this could be a mechanism that we could do, and then see if there's an agreement there, and then legislation. It wouldn't be for the board to pass the legislation, and I doubt it would be included in the sunset bill because of the controversy of it. But there is other existing legislation that is out there. I know we're not talking about bill language right now, so I'm going to refrain from that, but that's how it would be done.
All right. If there are no other questions from the board, thank you so much again. And we have one more presentation on this topic. Oh, sorry.
Facilitator, if you could move to the next slide deck. There we go.
Okay.
Dr. Mo, anytime you're ready to move to the next slide, just say, next slide, please.
Okay. Good morning, President Brandon and members of the board. I'll be providing some personal experience perspective as an animal physical therapist, both in Nevada and California. And thank you for this opportunity to represent my colleagues. Next slide, please. My name is Dr. Jenny Moe. I've been a licensed physical therapist since 2003 in the state of California. I became a certified animal physical therapist 16 years ago after receiving my CCRT certification from the Canine Rehab Institute. I have had the honor of lecturing at CSM 2020, and I've been the vice president of the APTA Animal Physical Therapy SIG since 2020. In addition to being a physical therapist, I am also the owner of one of the original custom animal wheelchair companies in the US, Dog on Wheels. You've just heard about the broader policy landscape from Karen. My goal is now to humanize it for you and present what these regulatory structures look like in real clinical life through my professional experience both in Nevada and California. Next slide, please. I was beyond lucky to find a specialty veterinary practice who was looking specifically for a physical therapist to expand their physical rehab department. The surgeon, who is also a CCRT, recognized the unique skill set and expertise that we offer as PTs, especially regarding manual therapy. I expanded that practice from 1 to 2 clinics, brought another PT on board, and educated both the specialists and general practice veterinarians on what we could actually do for their patients. I worked side by side with surgeons, neurologists, internists, oncologists, and more, as well as rehab veterinarians. They valued my expertise as a PT, and I valued their medical expertise. Next slide. I chose Nevada solely because Nevada already had the regulatory framework. Actually, excuse me, can we go back one slide? Okay. The only thing I missed here was that my dream of opening a mobile practice to be able to serve pets in their home was impossible with the restrictions of the California Veterinary Practice Act. There was no pathway for me as a PT to legally be able to provide rehab services outside of employment or partnership directly with a veterinarian. So you can imagine the costs of having a veterinarian side by side with me in that model would not be effective. So like many others, I chose to leave California. Next slide, please. I chose Nevada solely because Nevada already had that regulatory framework that allowed me to practice my profession of animal physical therapy. The process of obtaining my Nevada APT license was straightforward. I already held the appropriate certification, experience, and professional recommendations required to obtain that APT license from the veterinary board, and the PT license was equally as clear to obtain in Nevada. I took advantage of an existing opportunity to open my own business, sharing an existing clinic space with a rehab veterinarian who wanted to focus on other aspects of her practice, and my role is to take over incoming rehab patients. Next slide, please. This image was presented at the Senate Business, Professions, and Economic Development Committee informational hearing on August 25th, 2025. It was presented by Jennifer Pedigo, Executive Director of the Nevada Board of Veterinary Medical Examiners. It provides a nice visual of how Nevada allows animal physical therapy, and we'll get into that since it's probably a little tiny for you to read. Next slide. Nevada's animal physical therapists are regulated under the veterinary board. PTs are granted a professional license from the PT board and the certificate of registration from the Nevada Veterinary Board. Animal-specific coursework is required along with supervised hours and a professional letter of recommendation from a veterinarian to obtain the animal physical therapy license. Also, to add to the question about continuing education, at least in the state of Nevada, each year, much like the CE requirements for a PT license, there are required animal-specific CEUs required to maintain that certification. PTs retain liability for their own services. Patients may be seen with a current relationship with a veterinarian and referral, and discipline and complaint processes are clearly defined by the veterinary board. Next slide.
Overall, my experience in Nevada was overwhelmingly positive. Patients improved, veterinarians were supportive, regulatory clarity helped everyone, including the public. Nevada provides or proves that a referral-based collaborative model can work. Next slide, please. Even a good model can have limitations, especially with my chosen location being State Line, Nevada. Although Nevada's system worked well within that state, many problems were exposed in my reality of communities straddling these state lines. My path to practice animal physical therapy should have been quite clear. I held the appropriate licenses, had referrals lined up, but California's legal framework put up roadblocks. Most of my clientele would be from neighboring communities such as South Lake Tahoe, which are part of California. The primary veterinarians were happy to refer to me. However, because California state law prohibits them from referring to non-veterinarians, they could not do so. Clients had to pay for an extra evaluation with a Nevada veterinarian, often doubling the cost. For some working families, this was a barrier to access rehab services. They had to choose to spend more, wait longer, and sometimes skip care altogether due to finances. This barrier proved to be a significant contributing factor to my decision to return to the Bay Area. Nevada's model works well in that state, but California is a larger and more complex system. History has shown that the structure here cannot successfully be scaled. Next slide, please. When I returned to San Francisco, I expected to bring the skills I had used safely for years, but California's regulatory structure leaves me and every highly trained animal PT with only one option: to work for or in partnership with a veterinarian or not work at all. Next slide. I cannot open a practice. I cannot provide in-home services. I cannot meet the needs of clients who ask me daily for help. There's no other health profession in California that allows highly trained licensed providers to be legally blocked from practicing their specialty. Next slide, please. As a PT who has been certified for nearly 16 years, I am one of the most experienced animal physical therapists in the state. I have expertise and skills many other rehab practitioners are hesitant to offer, such as fitting custom orthotics and prosthetics and other custom assisted devices. Next slide, please. My approach to manual therapy, bringing skills perfected in my practice as a pediatric PT, lends itself naturally to animals. A lot of people also attended the fascial conference, which would have been really amazing to attend. I've been able to achieve results when others often struggle. I have not found the setting I would like that fits best, having returned to California, to be able to practice and offer these skills to the animals who need that help. I am an eager and skilled therapist who would love to have my own practice in California, and yet I am unable to independently serve my community. There is a huge need for more practitioners, and physical therapists want to be part of this field. Next slide. The need for more rehab practitioners is real. This is happening today in California, in every region. In the San Francisco Bay Area, where there are several neurologists, surgeons, and other veterinarians looking to refer their patients for therapy, there are wait times exceeding 3 months just for an evaluation. This isn't theoretical. The need for rehabilitation far exceeds the capacity of current providers. The public is suffering because the law has not kept up with modern practice. When animals cannot get in for therapy services, their conditions be worsened. Excuse me. Families struggle to care for them physically, emotionally, and financially. Unfortunately, some animals do decline beyond recovery. Families are forced to face the tragic reality of an untimely goodbye because they could not access care. Veterinarians consistently tell us we need more rehab providers. Next slide, please. So if things work well in Nevada, why shouldn't California use their model? Both times animal physical therapy bills were making their way through the legislative process. The California VMB projected high regulatory costs and used inaccurate assumptions about PT training to block their progress. Both attempts resulted in no workable pathway for licensed PTs. Nevada's structure is not the problem. Our regulating body is. Nevada's veterinary board embraced the model in collaboration with the physical therapy board. California's veterinary board has rejected it twice, despite stakeholder consensus and national trends. The barrier is not the mechanics of regulation. The barrier is the longstanding structural bias and misalignment of expertise within the VMB. Next slide. We're almost there. Nevada shows that animal PT is safe, effective, and regulatable. But Nevada also shows us what California has tried and cannot achieve under VMB authority. We need a structure that avoids repeated VMB opposition, aligns with PT expertise and training, reduces regulatory burden, ensures public protection, expands access without duplicating veterinary work. A PT-based regulatory structure aligns expertise with oversight, prevents future conflicts, and mirrors the national model for regulating specialized PT practice. Next slide. I am living proof that California's current structure creates a barrier to employment, a barrier to access, and a barrier to public protection. Nevada allowed me to practice safely, transparently, and collaboratively. California should offer its own residents that same clarity. Next slide. My request is simple. Include animal physical therapy in the PT's board's sunset review and report, and recommend statutory authority for this board to regulate qualified PTs who work on animals under veterinary medical clearance. Thank you so much for your time, your leadership, and your consideration.
Thank you, Dr. Mo, and especially thank you for sharing your personal experience and your path. And I think it's really to hear from people who have actually been in another state and had that experience as well. Are there any questions from the board? Any comments? Yeah, we can tell that you're as passionate as any other physical therapist about your clients and patients. So thank you again for what you do.
Thank you.
All right. We are moving on to the next presentation.
We do have two panelists available via WebEx with us today from the state of Kentucky. One is the executive director of the Physical Therapy Board, Stephen Curley, and the executive director of the Kentucky Veterinary Board of Examiners, Michelle Shane. We are a little limited for time, but if you could promote them to panelists so that they could introduce themselves.
This is the moderator. I've promoted them both up and they should be able to turn on their cameras and unmute their microphones.
In September of this year, we did a informational hearing with the Senate Business Professions Committee about a similar piece of legislation to what we're looking at, but for chiropractors being collaborative with the Veterinary Medical Board. Executive Director Shane presented during that, so I thought it would be a good idea. She has some insight into structure and how Kentucky has not only incorporated this for chiropractors, but a few other healthcare practitioners, and maybe also doing it for physical therapists in the future.
Hi, I'm Michelle Shane, Executive Director with the Kentucky Board of Physical Therapy. I see Stephen's just joining. Just wanted to offer a few comments from the licensing board's perspective in the Commonwealth. We do have a broad license category called Allied Animal Health Providers, or AAHP. Currently, that is designated for
Michelle?
animal. Yes.
Just 1 second. Michelle, are you on camera or just audio?
I'm on camera.
Okay, 1 second. Okay, please continue. Sorry for the interruption.
No problem. The Allied Animal Health Professional Provider license is currently only for animal chiropractic providers, and just this year added the equine dental providers. Our prerequisites for licensure include a board-approved educational program, which is done with these two groups in partnership with the National Association. We also review their national exam. We also have a state-level jurisprudence exam. Our legislator did open a legacy pathway, which is a limited window for application, includes letters of reference and proof of employment in the field. That's 10 years for our chiropractors and 5 for our equine dental providers. There is a strict limited scope of practice, prohibition on devices such as lasers, shockwave, ultrasound, electrotherapy, and rehabilitation activities, no medical imaging, surgery, prescription, prognosis, diagnosis, recommendations on diet or supplements, and EDPs have additional restrictions related to work in the mouth of the horse. They are required to do medical record keeping, retention and access, privacy. They have a duty to report to the board changes and are subject to compliance and disciplinary actions. Just to answer a couple questions that I've heard come from your board, communication is required with veterinarians. The veterinary board does recommend that an attempt be made pre-service, but does not prohibit services to be provided if the veterinarian is who holds the VCPR or veterinarian client patient relationship. If they hold that VCPR and non-responsive services can still be provided, but there is a post-service communication requirement of 3 days. For our animal chiropractors, there is no supervisory requirement. For our EDPs, we do have an indirect supervision requirement, and this is related to drug sedation on the horse. I've heard a lot of questions about how our disciplinary actions handled. In Kentucky, we have established an advisory committee modeled after the Texas Advisory Committee with their equine dental providers. Our composition is for each provider type, 1 veterinarian who specializes and practices in the area, and 2 AHP providers working together on a committee. There are subcommittees for each provider type. Their role is to review our legacy applications, review grievance cases in these areas, advise on board policy and recommendations on changes to statute and regulation. We are currently working and have been since 2020 on animal massage therapy provider inclusion. We did have a meeting earlier this year with both our Kentucky PT board and separately with the association to include physical therapists. However, no stakeholder work between the two groups has been initiated, and our legislature will want to see that before anything moves forward. The only thing I would like to add here as a broader perspective and why we see a trend nationally to include these professions under the veterinary board is in part to reduce consumer confusion about when they have work on animals, where they go to file that complaint. Further, veterinarians themselves are subject matter experts on the holistic animal. So there are, of course, instances of contraindication that may not be considered by some of these carve-out professions. You don't know what you don't know, regardless of training, but a veterinarian is going to have that knowledge. Also, a veterinarian board is going to provide consistent limits on scope of practice and be that single source, as I mentioned. And Stephen, I'll stop here and let you jump in with anything.
Yeah, my name's Steve Curley. I'm the executive director for the Kentucky Board of Physical Therapy. I just kind of tagged on here, you know, as Michelle commented on, we met with them. Kentucky's very specific for their PT law. It says individuals, and individuals has widely, physical therapy is for individuals. It's been widely determined that individuals are human beings. So animal physical therapy is not allowed in Kentucky. You know, sometimes we get complaints for individuals because of the high amount of animals that we have per capita. We get complaints. We send them over to veterinary board if it relates to vet, and they send us if it relates to physical therapy, and it works well. But I'm happy to answer any questions if you guys have them.
Thank you both for joining us via WebEx. Does the board have any questions for Kentucky? representatives? Yeah, we really appreciate your input, and it sounds like, yeah, it's developing across different groups differently, and it was nice to hear about kind of how your group is already, I mean, Kentucky's already looking at the dentistry group and the chiropractic group, right? So they're
Yeah,
already,
those are in
Mhm.
place right now.
Those are in place. Okay. Thank you
What
very
we
much.
have is a strong statutory framework to incorporate other professions as that becomes available. But we're happy to answer any additional questions you may have. Thank you for the opportunity to present today.
Thank you both. Are there any other questions from the board? Not seeing any right now. We'll take public comment on item, which is number 21, use of physical therapy in animal care.
This is the WebEx moderator. We're going to display.
Wait, we have someone in person first. I'm so sorry, sir. 1 second. Thank you.
Madam Moderator, please continue.
My apologies. This is the WebEx moderator. The instructions will be displayed on the screen for your reference. If you are interested in participating, click on the hand raise icon, center of your screen.
Elizabeth,
Individual identified as Grant Miller. And Grant, I'm going to send a request to unmute your microphone. And we do have a 5-minute limit for agenda item 21. Let me set my timer as well.
Thank you very much. Happy holidays, everyone. And thank you for bringing this very important topic before your board. It's always important to discuss these matters and become educated on them. And I'm grateful for the opportunity to make comments on this very important topic of obviously longstanding issue. Again, my name is Grant Miller. I'm a veterinarian, and I'm the Director of Regulatory Affairs at the California Veterinary Medical Association, also known as the CVMA. We represent California veterinarians and registered veterinary technicians, as well as students in the veterinary profession. Today, however, I'm speaking on behalf of a coalition of several veterinary associations, both locally, statewide, and nationally, collectively representing over 120,000 veterinary professionals. Our coalition is opposed to legislation or regulatory action that permits an expansion of physical therapists' scope of practice to include animals without a requirement of direct veterinarian supervision. While our opposition is rooted in numerous areas, the primary basis for this opposition is that the scope expansion is based on a minimal and limited certification course. Of particular importance, the current physical therapy certification courses are largely self-study based and focus mainly on the dog. Yet proponents of the scope creep are contending that they are competent to practice without veterinary supervision on all 735 species of animals that are cared for by veterinarians. These certifications have no standardized aptitude testing and no failure rates. Essentially, if you pay a fee to be certified, you will become certified. To support this fact, please note that on one of the more popular animal physical therapy certification program websites, the following statement regarding aptitude testing is posted. The final exam is a take-home, open book final exam with 14 days to complete, and collaboration with classmates is highly encouraged. If a mere certification course is enough to expand a physical therapist's scope of practice to include several animal species for which they have received no formal licensing education, then please ask yourself why legislation should not include a reciprocity clause to permit veterinarians to take a physical therapy certification course to practice on human beings. Because there is no animal training included in the core standardized physical therapist licensing curriculum, the CVMA feels that a certification course is insufficient to permit physical therapists to expand their scope of practice to animals without veterinarian supervision. In the best interest of consumers and to protect animals, the CVMA feels that the existing law, which is California Code of Regulations Title 16, Section 2038.5, is appropriate because it permits physical therapists to work collaboratively with veterinarians in a registered veterinary premises under direct supervision, or in the case of a range setting, when the veterinarian is in the general vicinity. Please note, there is no 911 for animals, and thus, if a medical emergency occurs during a physical therapy session, care providers must be able to provide emergency medical intervention on site. The necessary drugs and knowledge and skill to administer them may only be provided by veterinarians. Minimum standard regulation for registered veterinary premises require emergency drugs to be on hand and mandate a veterinarian licensing manager to ensure that they are used appropriately. The CVMA feels that the practice of veterinary medicine, which includes animal physical rehabilitation, should be overseen by the California Veterinary Medical Board, and that physical therapists who work on animals should do so under direct veterinarian supervision. While California's 13,500 veterinarians have physical therapy training as part of our core licensing curriculum and can meet the needs of California's pets and consumers in providing this care, we have nonetheless been receptive and collaborative in changing the California Veterinary Medicine Practice Act to create a pathway for physical therapists who wish to provide services to animals. After over a decade of discussion, multiple authorities, including the state legislature and the California Veterinary Medical Board, have concluded that physical therapists should work under direct veterinary supervision in order to provide adequate consumer and animal protection. Thank you very much for your time and consideration.
Thank you. Are there any other public comments online? We'll finish that and then come back to the room in person.
Yes, this is the WebEx moderator. I do have one individual, Caroline Adrian. I'm going to send a request to mute your microphone, and I'm going to set my timer to 5 minutes.
Good morning. I think it's good afternoon, just about now. President Brandon and members of the PT board. My name is Caroline Adrian. I'm a licensed physical therapist practicing animal physical therapy in Colorado for 26 years, where physical therapists are permitted to work on animals following veterinary medical clearance. I appreciate the opportunity to share what I've learned in Colorado and how it may help inform your discussion today. Colorado's model is built on 3 things: clear roles, veterinary oversight, and targeted education. First, veterinarians diagnose and provide medical clearance for their animal patients. It ensures that a veterinarian has medically evaluated the animal and determined that physical therapy is appropriate. Second, once the veterinarian has medically cleared the animal, licensed physical therapists with additional animal-specific training perform their PT examination, develop a plan of care, and provide our physical therapy interventions just as we do for our human patients, but using specific education tailored to an animal anatomy, physiology, and behavior. This may include post-op physical therapy, neurologic recovery, mobility training, strength conditioning, manual therapy, therapeutic exercise, orthotics, and many, many others. This structure works because the scope of practice are clear and complementary. Physical therapists provide movement-based physical therapy after the veterinarian determines it's safe to do so and appropriate. Colorado has now used this model for decades, and there are several important outcomes I want to highlight. First is safety. We have 0 reported harm or negligence cases involving PTs treating animals under this model. Second, improved access. Veterinary clinics we know are overwhelmed. Many do not have the time or the staffing to provide extended physical therapy sessions. Allowing medical clearance to PTs helps animals receive care faster. Third is workforce expansion. Most PTs providing animal services in Colorado are small business owners. Many of them are women, including myself, who have completed extensive post-professional training. And fourth, regulatory stability. This model has not increased regulatory burden or licensing fees. I also want to mention the training pathway that I developed through K9IQ's Transitional Canine Physical Therapist credential. It includes veterinary taught coursework, comparative anatomy, red flag screening, neurologic, orthopedic, physical therapy, documentation, and a hands-on module taught jointly with board-certified veterinarians and veterinary technicians. This model, this program is all based on our Animal Physical Therapist Special Interest Group of the APTA, our clinical practice standards that were published in 2019. This program is built around safe practice under veterinary medical clearance and strong communication and collaboration with veterinarians. In closing, Colorado's approach has shown that a veterinary medical clearance model can be safe, collaborative, and effective. It expands access without compromising animal welfare or veterinary oversight. Hope these observations are helpful as you explore how physical therapists may safely participate in the care of animal patients in California. Thank you for your time, and I'm happy to answer any questions.
Thank you. Are there any other online public comments?
This is the moderator. No additional requests from online. Thank you.
Thank you. We'll take public comment in person.
Good afternoon, Tamika Island, Executive Associate with the California Physical Therapy Association. Physical therapists are experts in rehabilitation for movement-related dysfunctions. Animals often develop injuries and medical conditions that can be effectively addressed with many of the same techniques used in human physical therapy. Physical therapists with advanced training in animal rehabilitation are among the most qualified professionals to provide this care. A framework in which veterinarians determine the appropriate level of supervision for each case appropriately balances professional expertise, liability considerations, and the veterinarian's clinical judgment. However, clear legislative action is needed to formally establish this collaborative model to ensure consistent standards and provide clarity for all professionals involved. Allowing physical therapists to participate in animal rehabilitation under a clear, collaborative legislative framework would provide the appropriate level of oversight necessary to ensure safe treatment of animals, just as has been performed in other states. It very effectively increases access to care for more animals needing these essential and specialized services. Improving veterinary and physical therapy collaboration will benefit both professions, but most importantly, will benefit the people and animals of California. Thank you.
Thank you very much. All right. Is there any more public comment on item 21? In person, not seeing any. We are going to move on to item number 24. Thank you to all that made themselves available for that presentation and traveled and prepared. We really appreciate your input and your personal expertise. 24 is board member elections. Jason, can you review what we need to do?
So there are a few slots for election today. First and foremost, for board president. So what I'll ask momentarily is for any motions for the board presidency. After that election, we'd also like to do the same process for vice president. Once those two are concluded, we can have a discussion about both the delegate position for FSBPT as well as the alternate delegate, and then what we call kind of our backup plan, and that is should a delegate or alternate delegate not be available to participate, how do we want to go about organizing the rest of the board members, either alphabetically or reverse alphabetically, to provide that opportunity too?
I would like to nominate Karen Brandon for president.
A second.
Madam President, do you accept the nomination?
I accept as long as I continue to have amazing support, and I want to reflect to those in the public, this is an amazing board. We absolutely take our job seriously, and we do provide a lot of opportunity to everyone. So I'm honored that you all want me a second year. I know that everyone is going to have a chance to do this really rewarding job. So thank you, and I accept.
And hearing no other nominations for presidency, we can go to a vote.
Karen Brandon. Aye. Samuel Q.
Aye.
Dale Armstrong.
Aye.
Aye.
Tanya McMillian.
Aye.
5-0, motion carried. Congratulations, Dr. Brandon.
Thank you.
On to the election for vice president and asking for nominations for vice president.
I'd like to nominate Dale Armstrong for vice president.
I'll second.
I accept. Thank you.
Not hearing any other nominations for vice president, we can move to a vote.
Karen Brandon.
Aye.
Sam Q.
Aye.
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 Tanya McMillian.
Aye.
5-0, motion carried. Congratulations, Dr. Armstrong, once again.
All right. So on to the next part of the process, and that is consideration for delegates for FSBPT.
I nominate Dr. Kalap for delegate.
I'll second that.
Dr. Keller, do you accept the nomination?
Are you going to nominate someone else?
I nominate Mr. Sam Wow to take that.
Well, first, just as the parliamentarian not in the room, you do or you do not accept the nomination for delegate?
Not yet. I don't accept it.
So the answer to that is no. So
No.
we are still looking for a nomination for a delegate of FSBPT. And I'm hearing, Dr. Caleb, you might have a proposal for that.
Yes, I would again nominate our ex-vice president, Mr. Sam. Sorry, the last name Q.
I will second that.
Mr. Q, do you accept that nomination?
I accept.
Are there any other nominations for delegate for FSBPT? Hearing none, we can have a vote for that as well.
Karen Brandon.
Aye.
Aye.
Dale Armstrong.
Aye.
Aye.
Tanya McMillian.
Aye.
5-0, motion carried. Thank you, Dr. Q, or Mr. Q.
And now on to alternate delegate. Do I hear any nominations for alternate delegate?
I nominate myself for alternate delegate.
I second that.
It's appropriate.
Are there any other nominations for alternate delegate? All right, hearing none, we can move to a vote for that as well.
Karen Brandon.
Aye.
Daniel Q.
Aye.
Armstrong.
Aye.
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 Excellent, congratulations. For our Plan B.
I nominate.
Plan B, staff would recommend that we adopt the policy that we have in the past to, if the delegate or alternate delegate are not able to participate, that we would just go down alphabetically through the order of board members for the next alternative.
Agreed.
Okay, sounds good to me.
Wonderful. Okay, we are going on to public comment, not on for items not on the agenda. And we have one more item after this, and then we'll take our break. Very short. Any public comment in the room for items not on the agenda? Okay, online, any WebEx public comment for items not on the agenda?
This is the WebEx moderator. If you are interested in participating, you can click on the raised hand icon or press *3 from your phone if you're calling in. At this time, I see no request for public comment.
All right, thank you so much, moderator. And the final item agenda for this morning is agenda item number 26, future items for the agenda for future meeting. Does anyone have anything to bring up at this time? Board members? Not right now. Okay, thank you. Is there any public comment or future agenda items? None in person at this time. Are there any online?
This is the moderator. I see no raised hands at this time.
Okay. Thank you. All right. Well, that is going to, are we going to conclude completely? No, we can't. So we're
We're
going
going
to
to
be,
recess for lunch.
can we skip? Yeah, we're going to skip the closed session agenda item. That's not going to happen. We're not going to adjourn yet. We have one more agenda item because some very special people are joining us today. So we are going to take a recess until 1:15. Is that correct? That's fine. Okay, thank you so much. We'll see you all at 1:15. Okay, thank you very much for your patience. We are now back in session for the last agenda item, which is our student Q&A. Jason, do you want to introduce the group with us?
Yeah, thankfully, we have students from the Institute of Technology in Modesto, and we have one of their program instructors who have asked to come up and introduce themselves.
There you go.
You got it.
Good afternoon, board. Thank you very much for having us. My name is JC Gonzalez. I am a PTA instructor, full-time core faculty staff at the Institute of Technology in Modesto. We're so lucky to be a part of this and be able to bring a couple of our students to ask the board a couple of questions that have been hindering now that they've gone through some ethical training. So if you could give them your professional and very, what's the term I want to use? Unbiased response, I would be greatly appreciated.
All right. I think council has just one word of caution.
Yeah, just briefly, and this is really more for the board, just to make a record that the board has concluded all of its business except for the question and answer session. We are below quorum now. We can continue and we'll have the question and answer session, but just in terms of the board, we can certainly respond to and ask questions back, but we shouldn't get into a discussion about any particular issues between board members and because where we're operating now, we can only really take information and have the Q&A.
So who's the first victim? When you guys come up, Caesar, it'd be better if they sat at the other dice. All four? Okay. If you guys want to come up in a group, you can.
Don't be shy.
Seats at one time.
Everything's better together. You're not alone.
You could stage in the front row. I mean, it doesn't say anything about you as students that you all chose to sit in the back of the room for the whole board meeting, but yeah.
And introduce yourself.
Hello, everyone. My name is Travis Graham. I'm a student physical therapist assistant at IoT. And my question to you guys is when somebody provides false documentation or in the case fraud in general, what are the usual repercussions?
We were going to go board members first this time.
I think we should explain the process, how it works. So, council?
You mean a PT or a PTA committing fraud or someone else?
In either or PTA, PT or PTA.
Okay. So it really depends on what the matter is. I mean, that's something that could be investigated by general law enforcement. If there's financial crimes, it could be investigated by the federal government, or if there's a conviction for any type of fraud, the board would likely move to take disciplinary action on the license. Or if there's a complaint and the board makes a finding that's consistent with that, that could result in discipline for a PTA or a PT.
Thank you.
That was a little bit of a lawyer answer.
Yeah, I'm gonna go
Go ahead.
to an administrator answer. So as the administrator of the program, right, the thing that I think it's important for you guys to know as students is that we have documents that you can use to reference this, right? And so one in particular is the model guidelines for issuing citations or imposing discipline. And the intent or the spirit behind the creation of that document is, one, for you as licensees to know that if there's a violation of your PT Practice Act, what could happen? Should I expect to receive a citation? Should I get, put on probation? Am I going to lose my license? And that guide, which you can find on the website, is a really good kind of thing to kind of go through, because you can pick each specific violation of the PT Practice Act and the California Code of Regulations. And let's say, for your example, that you are found after an investigation by this board to have committed a fraud or dishonest act. So you just find that in that book, and it'll tell you, okay, in this instance, what you can typically expect to receive from the board is a variance from a citation for maybe a first-time offense. And that citation can range anywhere from $100 to $5,000. Or if there's more to it than just like maybe a single documentation error or a single visit that was billed when services weren't rendered, but we could establish a pattern, that would say all the way up to revocation or probation, and then even the conditions that we might apply to a probationary term that would say, okay, from that point on, you can no longer document billing issues yourself. You'll have to use like a third-party payer service or something like that. And I'm really sticking to your example, but the guide, right, the guidelines that we use touch on everything, any violation of the Practice Act. And so you can really kind of synthesize through it and see if this, then that. If this is a violation, what can I expect the punishment to be?
Thank you.
Hi, my name's Nathan. I'm a student physical therapist assistant. And my question to you is, do you think that the PTA license or profession career will become a 4-year bachelor's degree sometime in the near future?
It's a really good question. And I think in the last probably 4 months, there's been a lot of challenges regarding kind of the fact that the PT programs are as long as they are, and they're at the level they are. And currently, I think there's a lot of external influences, right, that have to do with payment, do with workforce, like, and really just what's needed in the medical field, right? We see other programs besides PT moving to a doctorate level. Like, there's still not 100% of occupational therapists that are doing their doctorate. There's still a higher percentage of masters in occupational therapy as the highest level of that license, right? And PT for certain has had a long-standing history of an associate degree for PTA. I think it's going to matter as we look at like the landscape of healthcare going through it, the next 2 or 3 years, to see if there's going to be an expansion of information and changes to like what PTs are able to do, and therefore what PTs are able to do. I don't see that changing tomorrow. There's not like a push for it yet, but I could be wrong. Does anyone have any other information to that?
Some context to add to it too. My mic's on, Caesar. Some context to add to it is that where would the board be involved in the decision-making process that might lead to like an advanced degree, right? That it's going to require a legislative change, right? So you're going to have a senator, assemblyman draft a bill, and they're going to do that based on some kind of stimuli. Somebody's going to have to come to them and say it's necessary for, physical therapy assistants to be educated at the bachelor level because there's a safety concern or what have you. And that bill will have to make it before the board, and the board will then may be invited to by the author to, opine and express an opinion, whether you see this going in the future or, like you've seen in some of the board materials, this board watches any kind of legislation that affects the physical therapy world. And the board may say there's a letter of support or there's a letter of opposition, and here is why, or if it's support if amended or oppose unless amended or something like that. So a lot of this is going to be about academia and where they drive it to, market share and the economy and where they drive it to for reimbursements and those kind of things. But the board will always be here as just kind of the gatekeeper of the Practice Act itself, right? And whatever the legislature hands to us is what we'll have to do.
Thank you.
Thank you for having us today. My question to the board, well, my name is Sierra. Thank you for having us. My question to the board is, what are the repercussions if a PTALA continues to practice and they have not passed their licensing exam?
Trying to figure out how long you can have your PTLA, LA, PTALA.
Did anybody tune in yesterday to the board meeting at all? Oh, okay. Because we talked about this kind of at great length. But so licensed applicant status is a privilege that is granted to applicants during your application process. And it was created in a time well before computer-based testing, right? When the tests were only given once or twice a year at a specific location, and you went in there and did your test with a number 2 pencil and a Scantron form, and then it would come back to the board staff, of which time there was probably 3 people at the board, And so PTLA was created to say, we want you to get into the profession as quick as you can. So here is this applicant status that allows you to practice under the supervision of another physical therapist until such time as we can grant your license, right? But one of the things that they said at the time was, if you fail the exam, clearly you've given the board reason to doubt that you might be competent. So you can't have that PTLA status past that point. So fast forward 25, 30 years, and we still have PTLA. Only now we have fixed date testing, computer-based testing. It's much quicker. We're a little bit quicker at issuing licenses now too, right? And so the PTLA is, I wouldn't say it's obsolete, but it's starting to become so, because sometimes we issue a PTLA and then the license within a day or two, right? But for those instances where one of our applicants is practicing under that status and they fail the exam, we give them a lot of information up front that says, if you fail, your applicant status is gone. If it's a simple misunderstanding or oversight, we'll take that into consideration, and it might result in, we're going to give you what we call an education letter, and we're going to go ahead and grant your license. It's on record. Don't do that again, right? But if in the investigation we can find that there's a little bit more intent to that, right? That they did it, they knew they were doing it. There's proof that bears out in the investigation that they were completely and well aware that they didn't. Then it becomes a little bit, it escalates in the concern, because now it's not just about that violation. Now it's an ethical issue. So like those guidelines that I was talking about, you'll see the variation, right? Ultimately, if they were practicing after they failed, they're now essentially committing the unlicensed practice of physical therapy services, right? And so then you look up unlicensed practice in that model guidelines book, and you'll see that it ranges anywhere from a citation to outright revocation. And it just depends on how extreme the circumstances in that scenario are.
Thank you.
You're welcome.
Hi, my name is Amy. I'm a student physical therapy assistant. And my question for you is, does the board plan on making it a requirement, or not a requirement necessarily, but making continuing education for PTs so they stay updated on the scope of practice for PTAs?
So as part of the JAM, right, which goes over our laws and regs, it's mandatory for everyone to understand the supervision requirements for not just PTs to PTAs, but also PTs to aides. And if in the course of a physical therapist's continuing education, they happen to take another ethics course or another laws and regs side course, they might get it, but there's not a current requirement unless you have had a disciplinary action in which one of the requirements may be that you have to take another ethics course or a specific course on supervision. But at present, it's a good question. We just expect that the physical therapists are understanding what is already in our laws. Anything further?
Yeah, so for your continuing competency requirements, right? Once you become licensed, you're going to have to do 30 hours every 2 years. And the only prerequisite, the only carve out that the board determined was appropriate at the time was that 2 hours out of that 30 should be based on law and ethics. Because, you know, regulations, statutes, they change over time. And you could be in your career for 15, 20 years. It's your obligation as licensees to stay up to date on what those changes in laws and regs are. As the regulator, we're going to do what we can to kind of push that information out to you proactively, but understand as licensees, ultimately that onus lies on you, right? It's kind of like, I didn't know that stop sign was there, officer, right? I didn't know that rule had changed. The obligation really stays with you. The other 4 hours is basic life support for a healthcare provider, which I think we could all agree, if you're working in a healthcare setting and something bad happens, we all want everybody to know what to do. The other 26 hours is, as long as they are given by an accredited, recognized approval agency and are physical therapy based or patient client based, we leave that to you as the licensees to choose, where do you want to go in your career? Where do you want to specialize, right? What do you want to do? And I'll tell you that when you say create a specific requirement, there are boards that do have some specific requirements in their continuing education. It's important to kind of look back about how that specific requirement came to be. Sometimes it was to address an issue or a problem that had happened, right? Like it's a common trend in enforcement that we're seeing this issue, so we need to reinforce this with a new continuing education requirement. And I'll say that the statistics for you guys don't really bear out or necessitate that I'm like, you got to learn how to supervise PTAs better, right? But at the same time, how do you think that the PTA scope has changed all that much over the years?
I personally don't have any experience out in the field, but from what we've learned in class, I don't think it has.
I can tell you just from the regulator's perspective, where our frustrations lie is that for physical therapy assistants, it's important for you all to know that you're being supervised correctly, right? And so you should at all times be able to identify who your supervising physical therapist is through the documentation, through a transfer of care, through anything that might work for whatever clinic, whatever facility or type of facility you might work in, home health, a hospital, or otherwise. There should be something on the record that it's easy for you to find out who your supervisor is, right? And that you practice within your scope yourself, and that you're also aware that you can't practice outside of that scope, even if your supervising physical therapist asks you to do so, right? And that's just a cautionary, tale from a regulatory board, because your license is yours. And I say this to PTs too, because they have external pressures that they have to deal with when it comes to payment models and insurance companies and all those kind of things. But your license is yours. It's your property right. It's the ticket that you get to practice in this profession. And it's the only thing that we have jurisdiction over. So if we find wrongdoing in those situations, both by either the PTA or the PT, it's the license is what we're actually taking away from you or putting a condition on or something like that. So fight for your license, right? If you think that you're not being supervised correctly, speak up. Now, I know that's an awkward conversation, right? Because they're probably your employer too, or at least they're more connected to your employer than you are. Be sure of what you're speaking up about, right? Make sure that you understand the laws and regulations, right? And if you think that you're being asked to violate your own practice act, point it out.
Thank you.
We were just talking about this in terms of like be in trouble if somebody was found to be, like, say, our current laws indicate that you need to be in contact with, and what the supervisory level is of a PT to a PT assistant, and say they had 3 instead of 2.
Yeah.
And basically, if the complaint came forward, would the PT assistant be in trouble? Would the PT be in trouble? How would that bear out?
So in that particular scenario, I'll just say could be, right? Like probably not, right? If you're being supervised by a physical therapist, I don't expect you as the PTA to keep track or keep count of how many other PTAs that PT is attempting to supervise, right? But one of the things I do often say is that for every complaint that we receive that mentions or involves a physical therapy assistant, 99% of the time, we're going to open 2 cases, right? We're going to open an investigation in a case on the PTA, but we're also going to open an investigation on the supervising PT, right? Because if they're letting unlicensed practice occur, like asking you to step outside of your scope and act autonomously and make edits to the plan of care, discharge summaries, or their job, right? Then I'm going to investigate them, and we're going to, take action as appropriate with them also. So.
Thank you. Okay. It's musical chairs. You can serve here, yeah. Push the button.
You can pull it a little closer too. Yeah, there you go.
Okay. Hello, my name is Mai. I'm a student PTA's. Yes. My question to the board is that while the reported unprofessional conduct involving a patient will be investigated, how can we as clinician ensure greater protections and support against unprofessional or inappropriate conduct directed toward us by patients?
Really good question.
All right. So when we do you want to try? Yeah, sure. Okay.
So to some extent that's going to be an employment issue. That was sort of my first
That's
thought.
what I was thinking too.
It is going to be, reporting that to your, I guess sort of depending on where you work and what type of office you work in, but every office should have a sexual harassment policy, should have a workplace violence policy. That is something that I don't know if the board would get involved in unless there was a PT
Potentially allowed
involved.
to happen.
I'm being intentionally a little vague here because I'm not quite sure how that would play out. But just in general, if that's happening to you, I would recommend you immediately reporting that to your supervisor and going through whatever, following your sexual harassment policy or other policies that are issued by your employer and making sure you protect yourself.
I think the nature of your question is because statistics show, as practitioners, you're more likely to be harassed by your patients than you are to harass patients, right? So we can't provide to you the same protections that we provide to the public when it comes, because there's no, your patients don't have a license for me to take away from them, right? But for discipline. But in the back of the room, there's a reference guide for you as students on how to handle these kind of power dynamic situations and to establish appropriate professional boundaries between you and your patients. You are going to be involved and are already starting to be involved in a very touchy-feely art and science, right? And you spend arguably much more time with your patients than other practitioners in healthcare do, which creates opportunities for confusion and misconception and some of those feelings to kind of develop and create what we would call kind of an inequity in dynamic. You guys need to be as prepared as possible with how to offset those kind of things very early on and to establish those boundaries and to make sure that something as simple as a accepting each other on a social media platform as friends doesn't turn into something that's completely inappropriate and rises to the level of the board's attention. Right. So again, there's a lot of copies of that back there, right? Where we put these kind of resources together to help you avoid those kind of situations.
I have a question for you that might come up. This was always interesting to me. Can I date a patient after I discharge them? What do you think? I mean, say it's been like 3 years. There's yeses and there's nos.
You can answer for a friend too. You don't. Maybe. There's one thing to know that in your Practice Act, there's a statute that says your patients are presumed to be incapable of providing consent for a sexual relationship, right? And that language is very much akin to like a statutory rape statute. That because that person is a minor or underage, it couldn't be consensual if you wanted to. So that statute's essentially saying that your patient is not capable of providing consent. And it's addressing that power dynamic, right? It's addressing that level of trust or that level of respect of authority that you as a licensee hold over them because they're coming to you for pain relief, and, you know, to make their life better. So just discharging the patient doesn't alleviate you from that kind of authority or that responsibility of that authority, right? That power dynamic still exists. We're not unreasonable people, though. In fact, we might even be a little romantic. Like, we understand that, like, you could find love at first sight, right? Like, patients meet their practitioners, practitioners meet practitioners. Like, we all know what's happening. But, and I give this as kind of that cautionary tale. It's all good until it's not, right? And one of the worst parts of my job is the enforcement part. So I'll just paint a picture, right? And these are just little tidbits of cases. All the names have been changed to protect the innocent. It's not a particular case. It's just little variables, right? But imagine that a patient and practitioner meet each other during care and they initiate a romantic relationship during that care. And that patient gets better and they get discharged, but they continue to date and they go on to get married and they go on to have kids, right? The thing for you to know too is there's no statute of limitations involving your Practice Act, right? So 13 years later, after a son or daughter is born, they decide they don't love each other anymore and they're going to get a divorce, right? And in that divorce comes a very awkward custody battle for the child. And one of those persons decides to file a complaint against their significant other for starting a romantic relationship 13 years ago when it was a violation of their Practice Act. Because it was all good.
Until it wasn't.
Until it wasn't, right? The beauty of being regulated by a board is that you have 7 members up here who are 4 professionals involved in your profession and 3 members of the public. And the beauty is kind of that trial by peer expectation, so that all the individual variables of your case are taken into account, right? And it's that a trial by peer, that trial of a jury of your peers is there to determine like what's reasonable and what should have been expected given the circumstances. So obviously 13 years later, evidence diminishes, but there's no denying that a violation occurred. We probably already have DNA from the 12-year-old, boy or girl that was born from that relationship. And we can overlap that with PT records that were from back then and see that they were, you were still providing physical therapy services during that time. So you create a really awkward position. So my best advice is, man, it better be love at first sight.
Stay that way. Yeah. Go ahead.
On a side note, just for the record, in order for us to maintain our positions on this board, is we have to take a series of trainings that they are mandated, and the sexual harassment, ethics, those are part of those trainings.
Yeah, board members have continuing education courses too.
Good afternoon. My name is Monique, and I am also a physical therapist assistant student. And my question today is the board currently reviewing or planning to review any proposals to expand PT or PTA scope, such as dry needling, imaging referrals, or other advanced practices in California?
Good question. We are part of our regular job is to look at legislation that's put forward, like our executive officer said, that relates to any healthcare providers, including anything specific to physical therapy. So it would be information that's coming to us, and it would be based on what it requires of our board to regulate, right? So at present, we haven't had any physical therapist assistant legislature come to us from the California Senate or House that indicates that there's going to be a change in scope. But also what I can tell you is in the area of PT, physical therapist assistant, maybe other states have things like adjusting the number of PT assistants that can be supervised, right? Like in rural areas or because of workforce issues. That would be something that I've seen in other states that comes to legislation. Can't think of anything else right off the top of my head.
A simple rule of thumb is for a regulatory board to push forward proposed legislation, like especially if it's considered an expansion of scope regulation, that it should be done with the idea of consumer protection in mind, right? So a good kind of tiebreaker is if the proposed legislation is good for the profession, then that legislation should be pushed by the professional association, because that's what they're there for. They're there to advocate for you as both PTs and PTAs. If it happens to be good for the consumer, then you could expect it to come from the PT board, right? If it's something that we're addressing to increase consumer protection or we're trying to put out an emergent situation, right? If it happens to be good for both, right? Which some of these things often are, they're good for both the profession and they're good for the consumer. Those should still be done by the association, because the last thing that you can have happen is have the regulatory board be seen as promoting the profession, especially in lieu of consumer protection, right? Because essentially we're here as advocates for the consumers of your services, where your association is there as advocates for you as licensees. Does that make sense?
And earlier today, I don't know, there's several of you here, the California PT Association representatives were here. Mhm. Thank you for your question.
Council have any?
The only thing that I was sort of thinking sitting here is so the board is the body that implements laws and licenses, disciplines, but if a new law is made that impacts physical therapy practice, including expanding the scope to include dry needling or other things, the board would implement that. But the body you want to be engaging with is the California legislature. And, really on this or any other subject, you are always free to call your local member of the Senate or Assembly and work with your professional organization and advocate for those types of changes. But it is, it's sort of the old how a bill becomes law. The legislature creates the law, the executive executes or enforces the law.
Hi, board members. My name is Paola, and I'm a student at IoT, a physical therapist assistant student. My question for you guys today, what are the most common reasons new PTA grads get cited or disciplined, and what steps does the board recommend to avoid these career mistakes?
The most common that I've seen since I've been on the board, and by the way, I'm a public member. I am not a PTA. The most common that I've seen in my 6 years now being on the board are DUIs. Yeah. Yeah, and the discipline, the citations, I'm gonna hand that over to council.
Yeah, so
They
there's an
vary.
interesting, I like to say the three most important things that you should do as a new licensee is you have to realize that you have this piece of property that it's no one else's, and you can lose it. And so at that moment when you've been out having a good time and you go to get in the car, you now have another reason to be careful in that instance, to not drink and drive. So I always say the three best pieces of advice I have are don't drink and drive, don't drink and drive, and don't drink and drive. So there can be practice issues with PTAs, although I think that's not quite as common.
Is it all right if I ask you guys kind of a question back and then just respond by like a show of hands? Because I'm going to try to tailor my answer to what I think is like best for you, right? Do you think, so when you say what's the most common reason, do you think it's common that a PTA gets their license disciplined or sanctioned? Okay, good. All right, so that's a good sign. How many active PTAs do you think there are in the state of California? Yeah, do you have any idea, like numbers wise? It's about 10,000 of you in California alone, right? But what I don't want you to think is that when you say like, what's the most common reason, that the numbers that we're going to talk about are really high, because we only sanction about 60 licenses a year, right? I mean, like and that's PT and PTA both. And if there's 10,000 of you, that means there's 30,000 PTAs. So out of 40,000 people, 60 a month or 60 a year, formal discipline. And then citations, we'll just say probably another 60. But to Tanya's point, Uber and Lyft
Are your friends?
That's another part of the job that I don't like, is then, reviewing criminal history, or even in the worst circumstance, there's no criminal history and you're a step away from getting your license. And let's just say you just passed the MPTAE, right? And you went out and celebrated and you had a couple drinks, but not enough to where you thought you were drunk. But then at about 12:45 in the morning, you rolled through a checkpoint, right? So nobody even saw you driving across crazy lanes or causing an accident or nothing. You just went through a checkpoint. Then you blew into a breathalyzer and you hit that 0.08. And now you have a DUI. Well, when you apply, you submit your fingerprints as part of a criminal-based background check. And we subscribed to those fingerprints for as long as you have a license. So when you got arrested, 2 days later, we got notified. And I was about to give you a license because you just passed the MPTAE, but now I have to look at that criminal history. So Uber, Lyft, and just really understand that anything and everything that you do speaks to your judgment, and your judgment is your key tool and responsibility as part of that license. And so if we have reason to question your judgment, and then we have reason to question your judgment when it comes to all things physical therapy or physical therapy assisting. And that license starts to, what do we do about that? How do we protect the public? How do we make sure that that person's still safe to practice? The other thing I would say too that's really important for you guys to know is that whatever it is that we do choose to do against that license, it's against the license. It's not against the person. And everything that we do is not considered punitive. We're not doing it to punish you as the license holder. What we're doing is to put safeguards in place to make sure that you are still safe to practice with the public while utilizing that license. And so when you see somebody on probation and we give them conditions, and to Dr. Brandon's point, that's when we might take and assign certain continuing competency courses. Like you need documentation courses, because in our investigation, your documentation was absolutely like non-existent. That's why we do it, is because we're trying to keep them in their place of employ, but remediate them, rehabilitate them to the extent that we can. But if there comes a time where we don't think we could, then revocation is the only other option.
Yeah, I was gonna, go ahead.
Just one little comment off of what Jason said. If you notice the example that he used, that person wasn't at work. A lot of people have this misconception that that can only happen if you are at work, and it does not work that way. So a good rule of thumb is if you've been drinking and you get in the car and you buckle yourself in, you're buckling your license in the passenger seat.
That's a great one. Yeah, I was gonna say to that point, it is very expensive. Like a profession, you've invested in to get this education, and then to have something happen to it is very frustrating, upsetting. I will also say that if you flipped it and remember that this could be your mom or your, kid or your best friend who you're putting their care in jeopardy, even if the person's just belligerent, whatever it might be, you have to think of it like that. And I always think of it like, okay, these are physical therapy practices. What if it was a surgeon, The other thing to note is that I think it's really important that you realize, again, like Mr. Kaiser said, we're not out for punitive nature. So if you have a one-time out of the blue incident that occurs, that's not the same level as realizing that you have an addiction and we know you need help and you recognize you need help. And in both circumstances, we want you to get the help you need. There are things in place at the state level for nurses and pharmacists and physical therapist assistants who are going to need help, and they need to be checked in and they need rehab. So recognize that that is not a particular thing to PT assistants. It is something that we recognize, but also the remediation is different for a one-time out of the blue situation versus someone who's had repeat problems. And the final thing is, if you ever, any of your colleagues or friends have something come up, please encourage them to get to the board first. We have a real problem if we find out about it after. That's actually a whole nother, isn't that discipline? If you didn't let us know.
Yeah.
Yeah.
So that fingerprint obligation that we have is after you're licensed, should you have that kind of interaction with law enforcement, the requirement is that you notify the board within 30 days of any arrest and 30 days of any conviction. So to Dr. Brandon's point, it might seem like, don't tell the board, but the board's already going to find out because they're going to tell us through your fingerprints. So let us know as soon as possible. That's the dark side. What I want you to see is the light side of it though, too. You're also consumers, right, of the state of California. So PTBC is part of a larger department called the Department of Consumer Affairs, right? The medical board, the dental board, respiratory care, nursing, all the way down to like the contractor state licensing board and the Bureau of Automotive Repair, right? We're here to protect consumers of certain services. And I hope, right, that you find solace in this structure because, like, for your loved ones, your parents, your brothers and sisters, your kids, that there's a regulatory board that is providing oversight of the healthcare practitioners that provide them services too, right? And I just, because I can't resist the temptation. How many of you know about the BREEZE system for applications yet? Not yet? Okay. So this is kind of an unfair question then. But did you know that you can verify the license of any healthcare practitioner that you receive services from? Has anybody done it? No? Good for you. Okay. There's a couple, right? Have you ever used like a website or an app like Yelp to review a restaurant? Yeah, everybody's nodding their head now. But you didn't go and look at the same review process for like a dentist who's got his hands all in your mouth and or somebody that's about to cut you open for a certain, I'm just verify not only for you, for your family. When you become a licensee, you can use that verification to verify the license of your physical therapy supervisors and your fellow, people around you. Because if you're working in a large clinic and you find out there's a bunch of people in the clinic that are working with you, but their license is expired, especially if that happens to be your supervising physical therapist, that's a problem. But you can head all that off by just saying, hey, I verified your license this morning. Did you know it's expired? You better take care of that. It's there for you as consumers too.
Well, I was just going to add the one thing I kept thinking about during this discussion is I'm not going to suggest to anyone how they should handle particular employment situations, but you all can file complaints with the board.
Absolutely.
If
the whole structure of regulation, take physical therapy as an example, right? 70 years ago now. Yeah, 70 years ago, I could say that. There was no licensure for physical therapists, right? It was more of an assistive personnel that provided services to a physician or surgeon. But as it started to become more of a specialty, it rose from a certification to then a registry, and then from registry to formal licensure. The driving factor of licensure was from you as PTs and PTAs yourselves. You wanted that legitimacy, right? You wanted that, we want to be self-policed. We want a clear set of rules that says, here's the black and white of what we can and can't do. And we expect the board to enforce those rules. So it sounds like we're the big bad government agency. But we're the big bad government agency that was created by you as the profession, right? To help you, retain that credibility with the public and make sure that we protect you as reliable practitioners from any of your colleagues who might not be so reliable, so they don't put a stain on your profession.
Hi, my name is Muddy. I'm a principal therapist assistant student, and my question is, are there any future plans to expand the PTA scope to include animal physical therapy in California? I know I should ask this sooner, but
Well, I think there is a bill pending. And that would be, again, a piece of legislation that would happen in the legislature. That's where that process would occur. If there are duties assigned or however, if that proceeds and is made law, then the board would implement those changes in whatever way the legislature decides. So, yes and no is kind of the response. And what's the bill number if folks want to follow it?
AB 1458. And you guys sat through presentations this morning all about this topic, right? So you heard some of those kind of things. I also like to use metaphors to make things simple, right? So sometimes I describe it as we're just the sheriff of the PT Practice Act, right? So we enforce the laws that we know and have in front of us today. That legislation, as it's being proposed, when we are invited into that conversation by the legislature to, what does the board think? The thought process that's involved into that is like, what's good for the consumers, right? What's good for the people of the state of California? Our current PT Practice Act clearly says person, right? So everything that we opine on, everything that we look at is that our consumers are human beings. Unfortunately, not unfortunately, I guess, to be considered is that there's another regulatory board involved in this discussion, that's their sole responsibility is to regulate veterinary medicine. And so it's been a long-standing conversation. I've been doing that part of this conversation for about 15 years. Do I see a solution in the future? Yeah, I really hope so. I'm tired of talking about the same thing over and over again.
Thank you. All right. I know. How did that work? Are you the last group?
yes.
Yeah, okay.
It's like whole panel and great questions.
Hi, my name is John and I'm an SPTA. And my question for you is the board reviewing any potential expansions or clarifications of the PT scope in regard to supervising PTA or physical therapy aides?
Tell me a little bit more. Is there a particular, is there something about supervision of PT aides that you're honing in on, or?
Not particularly. I was just thinking about in terms of what I learned in my ethics course.
Okay.
I know that a lot of the responsibility lies with the PTs.
All of it.
All of it.
All of it. Okay. So like, I guess, how many aides can a PT supervise at one time? How many assistants?
How many assistants?
Yeah, how many assistants can a PT supervise at one time?
I believe it's 3.
Two.
Two.
Two simultaneously. And an aide, it's even more restricted. One aide at a time doing patient-related tasks, and it's direct supervision, right? That PT has to be able to intervene and take over if something happens. So I will tell you, as the person that reviews the complaints, right, that sometimes we're not happy with the knowledge or understanding of our licensed physical therapists and how they utilize aids, or maybe overutilize aids, right? But you'll also see, like in our disciplinary matters, that we address those, right? Those folks need remediation, re-education, and rehabilitation to be taught the error of their ways. Like, we're aware that it happens. I don't know that we could be more clear in our restriction than you can only supervise one aide simultaneously doing patient-related tasks. And then even in your documentation requirements, right? PTs are supposed to document who does what, right? Whether they administer the care, whether the assistant administers the care, whether the aide administers the care. And I guess the only other thing that I add to it is we only see, when we're doing an investigation, we see people fit into 4 different categories, right? One is the victim, the patient, the person who filed the complaint, the licensee, and then assistive personnel, right? Whether it's an assistant, and I would say that's a licensee too. So maybe it's just 3. But the last category is aide. And everybody that comes up in the investigation, if they're not the patient and they're not a licensee, then they're an aide, right? Even if they're an administrator or a janitor or what have you, the difference is whether they're doing patient-related tasks or non-patient-related tasks. So nothing that I think that I could recommend is putting forward as like a further increase. The other side of that the board's responsible is disseminating information, right? And making sure that our licensees are still up to date. So we do newsletter articles, social media, the website content that we provide that's, supposed to be there to, for them to reference and stay up to date, because we talked about the onus being on the licensee. And then that's the whole reason for the presence or the existence of the enforcement program. It's we're here to, receive those complaints, investigate them, and see if there's any wrongdoing. Yeah.
Hello, my name is Alejandra, and my question is in relation to the pending legislation on pelvic floor physical therapy coverage. So if this legislation were to pass, what changes do you foresee for the physical therapy profession in the state of California?
I presume you're talking about the legislation to allow postpartum care to be covered for Medi-Cal up until 12 weeks.
Yes.
That's 4th trimester. Yeah. So the question is about regulation, or the question is about services like insurance coverage, or?
Yeah, more relation to coverage if it were to expand, if there's any changes, if at all, do you foresee for physical therapy?
Yeah. So as it stands right now, Medi-Cal doesn't have coverage for physical therapy for most conditions. And this is going to allow patients to be able to apply with a referral for therapy for that and have coverage. It doesn't really touch on anything else. And it doesn't change the regulation on our end either. It's more about a coverage issue that wasn't in place, and for those that have state insurance specifically.
Okay.
But it is, as a women's health clinical specialist, like it's a very exciting thing because it's been very frustrating that patients, just because they have Medi or Medi-Cal specifically, couldn't get those services without paying, and they didn't have the ability to pay in many times. So
I think I mean, it definitely increases access to care
Mhm.
as a result. And I hate to be like this statistical pessimistic who's like, well, if the increase the care goes up, then we can expect to receive an increase in complaints exponentially, you know? No. But I guess one indication that sometimes is kind of a misnomer or a misconception is that the board and the regulation of that license that we talked about involves reimbursement or insurance and payments and those kind of things. And sometimes it does. I mean, it certainly does in an investigation if we found out there was an issue of like misrepresentation where services were billed but not rendered. And so then the consumer is the victim. But other than that, right, when we're talking about how much you as assistants or how much physical therapists are being reimbursed for, that's a market driver. And that's going to be handled by the association because it's the interest of their licensees. And more importantly, I think in this case, that legislation is a benefit to the consumer because it increases that. So you would probably, and you did see in some instances where this board would offer a letter of support to the legislature for bills like that.
Hi, my name is Cerise, and I'm a physical therapist assistant student from IoT. My question is, will the California Physical Therapy Board let PTAs treat animals in the next 5 years?
It's not a matter of whether the board will let, right? Again, it comes back to, will the legislature provide that authority to the board, right? And then what the interest expressed will be that of consumer protection at the time. And so we also have to identify who's consumers of what regulatory boards. So, I mean, it's more of the legislature than it is on the boards themselves.
Hi, my name is Sherlyn Abagat. I'm a student PTA at IoT, and my question is, how is the board going to respond with the Department of Education new ruling of professional occupations?
I will tell you. So as the administrator of the program, the initial impact of that bill happened probably almost a year ago now, right? But there was something that happened about, I want to say 45 days ago, or about 6 weeks ago, that this idea of what a professional degree was just took like wildfire on social media. And so I got really nasty emails about like, what did you do? What is this board going to, what are you going to do to combat this? And part of it to understand is, again, when we talked about there's very little jurisdictional coverage for us when it comes to insurance and payment and reimbursement, we have even less to do when it comes to how your education coming up as physical therapy assistants and physical therapists is paid. We talk about accreditation of schools and we make sure that minimum competencies are there, but how the money is distributed at the federal level or how loan payment restructure is set up is non-jurisdictional for us as a board. But I also say that was a federal bill, right? And that federal bill that was passed trickles down to states and local government agencies, but we just have to follow whatever that federal statute was. In this case, it doesn't really touch us or affect us. I know as a profession, it can be very offensive for you as future licensees. The other part is I would say, do your homework, right? You'll find out that there's some kind of misinformation on social media. Who would have thought that happened, right? But I had been tagged in dozens of Instagram and Facebook and now because we have a TikTok account, TikTok Reels, of what we're going to do about these changes in definition for professional degrees. But the funny part of it was the physical therapy wasn't on that list before then, right? So when they're saying that they took it off the list, it's just like, well, the list was never really utilized the way you think it was, and it didn't have everybody on it that you think it did. But man, when social media hits and gas hits flame, it spreads like wildfire. So we had a lot of interaction and backside conversations like, how do we deal with this? Because some of these emails are very specific. They want an answer to what the board is going to do and how we came up with this determination in the first place. And it's like, well, that's a federal bill. The board not only did the board not have anything to do with it, the board was never consulted, or any board for that matter, deciding on how educational loans were going to be dispersed or repaid.
And whether it's fact or fiction, I think that it's unfortunate that it does impact people in a different way, but there are other things that you can look at that will impact how the workforce is in California and in each state. Physical therapy, things that impact it are going to be changes in legislation that have to do with reimbursement, that have to do with accreditation of schools. And in this case, if it were going to impact how much school costs for people, it would impact how many people go into that field. And there is data out there from the APTA that is shared, and also comparing other professional degrees and what their return on investment is in terms of like, okay, I put this much into school. How much am I expecting in the first 1 year, 2 years, 10 years of my practice? And they are looking at things like that. So while this particular thing was like a kind of flash in the pan, sensational moment, it was also a moment for you to reflect and really realize where we are in the scheme of things in terms of what things do impact that. And if something does change and all of a sudden we don't have as many PTs or PTAs in the state of California, then I'm sure the legislature is going to be like, well, what do we do now? How do we encourage people to come to California? How do we encourage schools to keep moving people through?
There's a couple recommendations that I would make about, utilize our website for information when it comes to the regulation of your profession. Visit it frequently, or at least, well, here's a funny, when you apply, you're going to give us your email address, and we're going to push out email blasts to you, and you can unsubscribe from those email blasts. But I'm warning you now that while you unsubscribe for them, I'm going to add you back to them like every 30 days, right? Because this is our way of pushing that, proactively pushing that information out to you as much as we can of any kind of change or regulation. But also, stay up to date when it comes to your local chapter of the association and the APTA and their legislative efforts. The National Labor Statistics website is another good place to go to look. So like when we were talking about this cohort, when you chose this profession, you all chose it because you want to do something good for people, right? You may have had a good experience with physical therapy yourself, or a loved one did, and you were inspired, but ultimately you want to help somebody, right? And you don't want to get trapped behind a desk or, regulated to 10 minutes of exposure to each one of your patients. That part I appreciate, right? But you also have to know, as you enter into the profession, how many of them are there? How many of you as physical therapy assistants are there? Because that's your competition, right? Are you entering into a field that's growing, or are you entering into a field that's just kind of stagnant? National Labor Statistics says that your PT and PTA are one of the fastest growing healthcare professions in the nation. Which state are you guys all going to be California licensees, or is somebody planning on going somewhere else? Yeah, defectors. Love it. There's not. Okay, good. Thank you. That makes that warms my heart. I guess the other part too, for information, and this is just, and your instructors know it, is that we will, we provide outreach to your cohorts. We'll come out and do demonstrations. We'll walk you through application processes, a menu of different kind of things that we'll offer to you. But that outreach is really there to make you better licensees and to make our consumers better recipients of your services, right? As we're trying to push out as much information as we can. Sometimes people just don't want to listen to us.
Great. Thank you all, and thank you to your instructors and the school for allowing this to be an important part of your education. We are still always here always can send a message, go on our website, and we do answer the phone.
Yeah.
We have real live people answering the phone. They're upstairs, by the way. We have a whole department here to answer your questions. So thank you
JC,
so
did-
much. Oh, you want it?
JC, did you want to add anything? No? Okay.
All right. So I think, is that all? That's everybody in the, okay. Okay, is there any public comment? Okay, do I have to do it online? Yes, okay. Any WebEx public comment?
All right, WebEx is open for public comment on agenda item 23. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few more seconds to see if we have a request for public comment. Seeing no request, you wish to continue?
Yes, thank you. All right, well, thank you all so much for attending, and I'm going to adjourn this meeting at 2:24 p.m. Thank you all, and we'll see you next year. Go
Thank
ahead.
you for making the long drive.
Yes, that was a big deal. Thank you.
Thank you.